Good afternoon, everybody. A very warm welcome on this hot afternoon. So humbled to see almost a full presence. It's like a deja vu of the last time, where we had almost a similar attendance for our arbitration meet on how to make India a great arbitration hub. Topic for today, again, most relevant in today's era, where now countries have become boundaryless. Internet has taken over. I think I can use the phrase that possibly God created human being. Human being created a thing called computer, thinking that it will solve all his problems. Ultimately, more than solving it, has created a monster out of it, which will be deliberated by all you seasoned campaigners out here. Just for the benefit of everybody, certain ground rules so that we stick to our agenda. We do have our chief guest and our sponsors who will be speaking, but we like everybody to possibly introduce themselves, and they can pick up a question or they can give an overall overview, but not more than 2 to 3 minutes. I'll say 2 minutes so that finally we end up, so that everybody gets a chance across, and then we have people who are taking down notes, and we decide to end up by 6 o'clock, as is our appointed time. And before that, we will also be releasing today officially the booklet, as we had promised, on the arbitration seminar that we had. And thereafter, we'll be circulating to all of you, including the earlier attendees, a soft copy of that book, and would wish that everybody comes back and gives us your honest opinion on how we can actually make India the arbitration hub. And the similar exercise we will carry out for this very debate also. And without much ado now, may I now, introduce two of my speakers, learned speakers here, along with my other colleagues. So on my left-hand side, welcome Chandar. Great to see you after a very long time. And Chandar needs no introduction, but still I have to do the formalities, so let me do it. He is the co-founder of the previously reigning IP boutique, Lal & Sethi Advocates. And Chandar is currently the senior partner and spearhead of the merged entity, Singh & Singh Lal & Sethi, India's leading IP litigation firm. And the two merged to form this IP powerhouse. So Chandar, you will be speaking maybe first, followed by Sanjay. Just to introduce Sanjay. Sanjay is the managing director, Netrika. He's a recognized expert in corporate investigation, fraud, security consulting, and risk assessment for over 20 years. And my good fortune that Sanjay, we know each other almost for the same period. And the distinguished audience out here, I can see so many general counsels, great law firm people. We would stand to possibly get the knowledge from each other, which will help us in our own respective arenas to make this world a better place, and also to create some kind of a legislation points which will help us. May I, before Chandra starts, may I just give it to Tabrezji to start the moderation proceedings.
Thanks, Ram. Welcome all. As a rule, we will be introducing, you all will be introducing yourself and then giving the expert opinion. So I stop here, let the two presentation go, and then we will be going around the table for your expert opinion. Please, Chandra.
Thank you very much. I'm a little bit handicapped, I must say, up front. I was hoping to bring my laptop in, which had all my presentations and all the acts, and I didn't do it. I sort of downloaded all the international acts and made a comparison. So I'm afraid, and I hadn't prepared very well without my computer. I don't work very well without my computer, but I'm here. I guess that's the first thing I would suggest in this forum is that if you're sitting in the Parliament House talking of cyber laws, and if you're not permitted electronics into it, there's something seriously wrong. And if you're still holding pen and paper, there is something seriously wrong. And on a more very serious note, I think this is something that certainly needs to look into. And if it takes 2 days to take permissions to get computers and laptops into sessions such as these, that needs to change. If computers become threats, I'm afraid that's a bit of a problem. So for a country like ours, which is essentially, I was reading, over 52% of our GDP is based on the service sector, and a large part of that service sector is dependent on IT. We should certainly have laws which are sort of at least up to all international standards, if not the lead standard, because like you all know, we've sort of jumped from where communications were very poor to the cell phone technology which came into India first, and we therefore leapfrogged over a whole set of technology for almost 20 years and went into the cellular world. And today we are the second largest holders of cellular phones in the world. And so a lot of our work is getting done electronically. There is obviously a great shift towards from paper to electronics, and India is largely viewed as a country where the cyber sort of the world comes and deposits its cyber information here. So the very first thing that I think we need to be deliberating is on laws relating to data security. And there is a very nice act, but I'm not sure how many of us have even seen that act and how many of us are implementing it, and I have not seen any sort of litigation happening on that, and there's an obligation on everybody who's maintaining records on an electronic form for and on behalf of clients, including banks, law firms, any other service provider, to make certain security arrangements. I think that directly conflicts with India's jugaad character, which is you can bring everything in and people walk into offices, walk out with disks and pen drives. And so there's obviously a great challenge here where the technology itself is making cyber theft very easy. The internet, all our computers are always connected to the net. It's not difficult to sort of break into computer systems and steal data. So I think data security, to my mind, is a fairly important criteria. Another aspect where we are currently litigating, and I feel it's a very, very important area for India and for the world, is where all of us, I mean, the entire business model of something like a Google, and it amazes me how much money they make out of their AdWord program. It's a great business model in the sense that we are all on Google. Anybody and everybody who in the near future or currently and in the future will be marketing goods online will have to have a Google account. You will be able to purchase what they call AdWords. So if you want your products to hit up front in Google on page 1, because nobody goes to page 2 today, you will need to pay Google. And if you know the program, their AdWord program, you have to pay up front, and then they deduct that money, what they call pay per click. So every business, and I've had clients come and tell me that for our own brands, we have to pay Google so that we come up tops. This is being litigated in the Supreme Court today, but I think this is something that the legislature needs to look at, because there's a huge outflow of money only because this indexing service based out of the United States will require businesses internationally to pay them to even exist, because the Walmarts of tomorrow are going to be online. The Walmarts of tomorrow are the Amazons of today. And as Walmart goes down, and I did a survey of all the big sort of departmental stores, they are all slowly shifting out of the brick and mortar, going on to the cyberspace. And so we have this mammoth with no competitive forces along with it called Google, which we will all have to pay for. And I think that's something that at some point needs to be deliberated. I'm hoping that the Supreme Court will deal with that issue, but I think it's a massive issue for the whole world. I'll just briefly touch upon two other sections which are coming up to on my mind. Is the section 65B, which I think is a welcome section for proving of electronic records, and the new Commercial Courts Act, which extends beyond the 65B legislation, where 65B dealt with issues where somebody had uploaded and was wanting to prove what he or she had uploaded on the computer, whereas now the Commercial Courts Act actually sets out material which is not uploaded by people, but also uploaded by third parties, and you want to prove in a court of law. I think these two legislations will go a very long way in in at least recognizing electronic documentation and their proof in courts of law. I think those are some of my initial comments which I think need consideration. Of course, cyber theft we'll all be deliberating about. I did have very good statistics. Unfortunately, my computer is not with me and I didn't take printouts. So my apologies for that. So with those few words, I would love to hear more opinions, and I'm sure I'll be contributing more during the course of the discussions.
Thanks, Chandar. You are well within time. So one thing is sure that even if without digital support, you did very well. Sanjay?
Yeah, I think I'll start with contradicting with Chandar that computers are not allowed. That could be a little bit of a problem. But I was talking with Ram that I think this is one of the forum where the mobiles are not allowed. Probably you allow the computers, but if the mobiles are not allowed, you're forced, even if you don't like the speech or you're bored to death, you're forced to listen to it. You don't have any other option. So thank you, Ram, again for putting me into a very difficult position, because speaking by a non-lawyer and a non-legal professional between the august gathering of such great legal professionals is very, very challenging job. But I'll try to bring out some value to the time which has been given to me. Information communication technology, or the cyber era which we talk, is an ever developing domain, and it's developing every single day. With technology becomes obsolete the day it releases. So if the new thing comes out tomorrow or the same day, it becomes obsolete. And looking at the laws, we all know that what it takes to get an amendment to a law. It takes a huge amount of time, the motivation of the government internal support, and whatnot. So we really need to look at the cyber law, which needs to be continuously evolve with the evolving technology on the day by day. Cyber investigations and jurisdiction, I think, is one of the very, very important issue which needs to be looked at. The cyber crime might happen in one of the jurisdiction in Delhi. The head office of the company could be in the Bangalore. The person who perpetrated this theft or the crime is sitting in Mumbai or some XYZ city. You go to one police station, one commissionerate, one cyber law office, and police very easily try. There could be laws, there could be other things, but police easily try to persuade you to go to the next police station or next jurisdiction, saying that this is not my jurisdiction. I think one thing which we very, very importantly need is one single jurisdiction, probably across country. There are laws, it's not that there are not. There is a law which says you can get an FIR registered, which is known as zero FIR, with any police station wherever the crime must have happened, and it could get transferred to the other police station. But I think in the cyber, it becomes very, very important. Another thing which is very important to look at is the cyber law or the IT Act must have certain provisions. But, and it has evolved, there are a lot of amendments which has happened. But what about the Evidence Act? Evidence Act is very old act, and when we look at the provisions of the IT Act, and when we look at the evidences collected in this cyber era, are we really looking at how do we collect these evidences? And has the Evidence Act actually been amended towards that? I think that's another area which needs to look at. And another thing is IT Act does not actually criminalize the offense. To criminalize or to get a conviction in any of the IT Act is very, very difficult. Another suggestion, and I was talking to one of my friend this afternoon before coming here, and he happens to work with the investigation department of one of the largest e-commerce company in the country. And I asked, what are your challenges? And he gave me a very basic idea, which is like you're fighting for Google, against Google for the Google AdWords in the Supreme Court. I think one of the basic idea would be, how do we create emails today? Just go to Yahoo, you go to Google, or go to XYZ platform, put certain details which are not correct, and create your email ID. Can't we have a law which says when you have to create an email ID, you have to give either your passport, either your PAN card, or your Aadhaar card. Once an email ID is validated, I think 50% of the frauds of this country would go down. This is something which is very, very important from my perspective as the investigative agency or the enforcement agencies when we work with the companies. This is one thing which we work on. And as Chandra has rightly said, believe me, next era is all about e-commerce. Every single thing is going on the e-commerce. I think that's all as of now. These are my initial thoughts. Probably will come back and try to contribute after hearing others.
Great. Sanjay, you also did fantastically well on time. So let me open it to go around the table to experts, listen to everybody. So, but just to give comment on two presentation, two talk, one thing is very clear that digital is going to be the thing we have to live with. Tomorrow there will be billions of devices when they will be connected, and when you go home, your fridge will talk, your phone talks already. So it's so difficult for you to maintain the privacy, and so easy for somebody to intrude and to match with law, which is very slow moving. There will always be challenge. So that's what I'm looking at. So what my request will be that please introduce yourself and give your observation, and maybe we will start from here. Yeah.
Thank you, Tabriz. This is Santanu Mukherjee, and I'm a partner with Luthra and Luthra Law Offices. A part of my work is on policy issues and statutory work. So very briefly, talking about the discussion today, let us go back to see what the parliamentarians are talking when they're talking in public. They're talking about, starting from the Honorable Prime Minister, we're talking of having a digital India, connecting the services. Earlier we have seen the government-to-government connectivity had happened. Now we are looking at the connectivity from the government to the users, the citizens, whether it is e-health, whether it is e-commerce, e-banking, or e-governance. When we are talking of that, we are talking of huge data. They can be private data, they can be government data, transferring from one to the other. When we are talking about big data being transferred, automatically we are talking about the security of that data. We can go deep into the micro details of that. I'm not going to go there, just highlighting that. There is a trend to move on to cloud computing for its own advantages. So when we are looking into cloud computing, we look into the statutory framework which is there in India or which is not there in India. We look into the IT Act. We look into the possibilities of having specific legislations or national policies. So there, if you compare, keep in mind the topic of discussion today, see what's the global practice, what is happening in the major jurisdictions in the world, in US, what is happening, in Europe, what is happening. Then you see whether our Meghraj is actually capable or not, or we need more than the Meghraj. So at that, I will leave, and I'm happy to come back again. And my understanding is to learn from this forum, to discuss in this forum and understand where we want to go, at what speed we want to go, to make sure that the technology, we cannot match the speed of technology with the law, but at least we do not go like in skit shooting, that after the clay pigeon has gone, then after the bullet goes. We should not go in that manner. We should make sure that we move forward. Thank you.
Good afternoon, everyone. I'm Jyoti Khetrapal. I'm Associate Director with Nitrika Consulting, working with Sanjay Kaushik. I'm a chartered accountant by qualification, not a lawyer, and we work on corporate fraud investigations and cyber forensics and other area. Technically, I'm not qualified to contribute here as such, but yes, there are 2 points which we have gathered during our observation, carrying out certain investigations for corporate. So I will start with 2 questions rather than contributing here, because I would like people present over here to share their thoughts on that. The first is when we talk about corporates, their perspective is that yes, we have enough laws enacted in India. We don't want any more laws. Why? Because purpose is not to comply with all the laws created by legislature. If they will focus more on compliance, then when will they actually do their business? So that is where they say that execution of available laws is really important, and the way these should be executed. There should be one single authority which should be guiding them on the jurisdiction, on the way they should be actually protecting their data, the way they have to monitor their infosec violation policies. So that is one aspect. Second is about training. We talk about digital India. Are we well trained on that? Are our people well versed with the new technology? Forget about new technology. The technology which was available 5 years ago. Are we capable of actually getting into that mode? So that is second question. With that, I would like to leave it over here. Thank you.
So just to add, I will request everybody here can contribute on this. You brought very valid point, okay? So I will encourage everybody to give your thought on that, okay? Please.
Hi everybody, this is Shweta Bharti. I'm the senior partner with the law firm Hammurabi and Solomon, and I'm into corporate commercial law practice. And the thought, I think, has started from Chandra and thereafter has been flown down. There are two issues which are actually necessary for us to dwell upon. One is whether our IT Act of 2000 is actually equipped to handle the kind of situation we are in and the kind of cyber world that we are actually living in. So that would be the prime focus, because if you look at the data privacy that we are going to talk about here, the data privacy has been handled, I guess, in terms of provisions like Section 43A, which is one limited aspect of discussion, and the second is with respect to Section 72A. Now, if you read Section 43A, the vagueness that exists in the section is that it does only talk about the damages part, which is the compensatory financial part. It does not talk about any penal provision. How is that damage to be compensated? How is it to be assessed is something which has not been discussed in as much detail. So if we try and compare it with the judgment that has been passed, the jury that has passed the judgment of EPIC, and in the TCS case, there is a quantification of damage, maybe by way of 1/3 of the total profit. But in India, that kind of a provision is not available under Section 43A. The second provision that I would want to discuss is Section 72B, because that is where, the whole issue is with respect to your contractual obligation and your violation of data protection. And in that also, if you see the terms and conditions, it is only 3 years imprisonment as compared to 5 lakhs of damages to be paid. So are they really adequate? 5 lakhs and 3 years, I mean, in terms of the losses that are going to be incurred, is that enough for us to actually charge those violating companies? And the second issue is probably it is time for us to again restart talking about the privacy bill, because that is something which started and which has not yet seen a concrete shape as yet. So maybe it is time for us to renegotiate and rediscuss on the issue of privacy bill. So these are the two issues that probably I would want to highlight on. Thank you.
Good afternoon. My name is Gagan Kumar. I am a tax lawyer. So I'll be essentially touching upon the legislative gaps on the tax law perspective, and Mr. Lal helped me in setting up the tone by mentioning the Google AdWords. Now, digital economy is a reality, and globally OECD has set up a task force to address this issue, and recently they came up with this publication called Base Erosion and Profit Shifting, wherein one of the action plan is to address how do you tax the digital profits arising from the digital economy. And India has taken a cue from that. And in this budget, we introduced equalization levy of 6%. The idea is to levy 6% tax on the advertisement revenue given to Google or people like Google. But the challenge there is that it is not part of income tax. So therefore, there is no credit available. There is no enforceability as to the withholding of that 6%. So end of the day, it may become a cost for the Indian businessman who would be contributing that equalization levy. The other aspect is the entry tax on the trade which happens through e-commerce. Now, entry tax is a state subject, and very few states impose entry tax, but recently Flipkart has been imposed with a huge tax liability by the state of Kerala on entry tax, and the matter is currently pending before High Court, wherein the issue came that the suppliers were not aware. So if someone is sending goods to Kerala, he may not be aware that there would be a possibility of entry tax, and he has not considered that aspect into his costing and pricing. And now there's a cost, so what to do? So these are the legislative gaps I thought I'll bring to the board. Thank you.
Good afternoon, everyone. This is Jyoti Singh from Ministry of External Affairs. Actually, I'm very out of place in this whole discussion because I come from a government background. But what I can hear and what I can get or interpret is that cybersecurity definitely is a very important area, because today's even Prime Minister's mail ID or Secretary's ID is not secured. Their mail IDs are being hacked, and we get mails from them that so and so is coming or so and so is going visiting, and the mail is fake actually. So we have to be always on our toes, and we have to see that the mail is really protected. And in today's era of privatization, globalization, and liberalization, it's very difficult. You cannot avoid the IT. Information technology is really spreading like anything. So cybersecurity definitely is very important. And one point I really agree is that the email, I think, should be verified, because that's a very good idea. Whosoever, I mean, he pointed out, Sanjay has pointed out, and that's a very good idea. Secondly, I'll say that all the acts like Cybersecurity Act, IT Act, and Evidence Act should be correlated and updated, and heavy penalization, according to me, is the way if really, we really want to stop the cyber security, I mean, piracy. Thank you so much.
Before the next speaker, Jyoti, I think you are at the right place at the right time, because you have already validated one of the points, and we are definitely going to come back to you and maybe reach it up to Mr. Modi's level.
My name is Kunal Gupta. I'm a partner with Cyril Amarchand Mangaldas. Ram, I'm going to do a bit of a segue from, it is not strictly a legislative gap. I think if you strip the rhetoric out of, the real day-to-day cybercrime that happens, someone who is an R&D head has taken all the IP in a pen drive and moved to a new employer. If you really look into those issues, I think there is a serious gap at how judges understand technology. I mean, Sanjay and his team can do very sophisticated cyber analytics, but unless these guys really understand, how does a copying differ from a forensic imaging, and what value does, let's say, a classic chain of custody has from an evidentiary standpoint, you really are, you can do as much analytics till the cows come home, but you really are not going to make sense unless those guys really understand and enforce that. So I guess that's the bit, my limited 2 cents on how, not strictly a legislative, but perhaps a policy level, that on a judge's training that needs to be taken.
I think awareness and the training, these are the two key points, whether it goes to the investigative authorities or the law enforcement agencies or the judiciary, sorry. So awareness and training is very, very important.
Hi everyone, my name is Kapil Chaudhary. I'm the India and SARC General Counsel for a software company called Autodesk. I'll just take the next 2 minutes to give you the broad overview and give you the framework. Coming from the software background, I'll probably place before you the latest data report that's come out this week. It's called the BSA, which is the Business Software Alliance. It's the industry association for leading software companies. They came up with a document called the BSA Cloud Readiness Report. It's been released this week. This report actually does a ranking of the top 24 countries which kind of control almost 80% of the IT market in the world. India, to kind of unfortunately has been ranked 18 out of 24 countries. Our rank has gone down from 17 2 years back. The top 5 countries are Japan, US, Germany, Canada, and France. So that's one yardstick. it basically measures India and all these countries on a certain set of parameters to test the legislative and regulatory environment, whether we are ready to become the next startup nation, the next cloud, and the next digital economy, which I believe we are getting there. The second proposition I want to present before this esteemed audience is, do we have a right to privacy in this country? And why I say that is, we've had conflicting arguments. The Honorable Supreme Court in the Aadhaar case last year, was asked this question. The Honorable Court has kind of put this before a special panel. We'll get to hear this. The Attorney General felt we do not have a fundamental right to privacy in this country. The Delhi High Court, in the case of NAS Foundation versus the government of the NCT of Delhi, in a writ petition in July 2009, found a clear right to privacy does exist. Having said that, India does not have a defined legislation on data privacy. We do not have a defined legislation on data security, and most importantly, we do not have a mechanism to handle data breaches, which to a lot of multinationals is a big concern. I'll probably end with giving you just 4-5 parameters on the basis of which a solid cybersecurity mechanism has to work. One is partner with the private sector. You'll have to come up with sectoral approaches. You're talking about edutech, fintech, health tech. Each of these will require fundamentally different frameworks. You'll have to adopt global frameworks in terms of data flow. The safe harbor is gone. You are now faced with the world of Privacy Shield and the General Data Protection Regulation, the GDPR. We'll have to start looking at adopting some of these frameworks, and we'll have to also adopt standards which are interoperable and flexible, and kind of reduce the localization requirements, because economies, countries will like a free flow of data. And as India becomes the next data hub, the next digital hub, every company, be it a Microsoft, IBM, or a Google, will like to decide where they want to store the data and where their servers should be located. So data localization, data harmonization, India has to kind of take a giant leap forward and decide whether we want to become the next big digital economy. Those were my initial thoughts. Thank you.
Good afternoon. My name is Samir Chog, and I'm a Director Legal and Regulatory for Bharti Airtel. I think while I'm sure everybody here, kind of being experts, will be able to turn around and say, kind of where exactly we need. But I sincerely believe that let's take a step back and actually first identify, do we have everything covered? Do we even know what are the changes we need, or what are the areas we want to cover? Because we all talk about saying that, data privacy is an issue, technology is moving so fast. I mean, laws, forget turning around and amending laws. I don't think today we even know where we are heading and what needs to be changed. To me, clearly, there is a big gap. And there are, kind of the big question to be answered is the what. What is it that we want to get out of the legislative side to turn around and address within the technological movement? I mean, technology is moving so fast. You obviously, rightly, you mentioned that, you can't catch it. But at least you got to identify what is it that you want covered, which then takes you into, kind of divided into two parts. What's existing that you want covered? What's coming up in the future that you want to address? Because existing, you have a situation where the critical pieces need to be, covered. So there's a 80-20 rule. You can't cover 100%. I don't think that's going to be possible. So of existing, let's try and cover at least whatever maximum we can to turn around and eradicate the flaws that exist. For the future, you can't turn around and get 100% as to what's going to happen, because technology moves faster. I mean, today, what is today in is obsolete tomorrow, which is obsolete tomorrow afternoon. So it is changing that fast. So for the future, you can't turn around and try and catch up with it, but you can say, okay, maybe what is expected 5 years down the line, 20 years down the line, can we start working towards in parallel? I mean, critically speaking, today, with the way information is available, with the way, kind of the world has moved, are no longer there when it comes to information. Papers don't fly around everywhere. You pick up your, information, forget you don't, I'm Chandar, to say, while laptop is good, but I think it's changed. Everything's on the phone. I mean, there are about 17 million smartphones in the country today. And going forward, very soon it will be about 40 million. There's a total of about 90 million subscribers on the phone. Data is growing at about 78%. That's where everything is. So everything's going to be on your phone. With banks, small banks coming, you will suddenly have everything on your phone. You don't need to go to a branch. You don't need to go to a branch today, but you don't even need a checkbook tomorrow. That's the reality. So important to then see what is it that's coming up in the future and therefore have laws or legislations which are in a way trying to address that. But again, at the same time, what we need to also look at is the practical aspect. You can't make laws which you cannot implement. I mean, rather not have them. Yeah. I think those are some of the areas that when we further go, and I mean, kind of in the interest of time, and I'll try to stick to 2 minutes, maybe I've already crossed it. But the fact is, we can talk about more details. But I think that is one aspect we should be looking at considering the overall piece that we're trying to address.
Suman, before you start, just a moment. In case anybody is thirsty, because of security reasons, we are not allowed water inside. So there is water outside. In case anybody is thirsty, you'll have to just go one by one to have water. Apologies for the same.
Good afternoon. My name is Suman Doval. I'm a practicing lawyer in Delhi. After all has talked about this digital economy and data and all this, but we are forgetting a poor man. We are the human face of all cyber economy. Who is talking about the poor man? Samir tells me 96% of the people in this Airtel data is a postpaid people, prepaid people.
Sorry, not Airtel. The telecom.
Telecom sector. Telecom sector is the prepaid people. And I believe that out of the 96%, at least 50% are those people who are faceless, are maids, ayahs, and all the people living below BPL, who are using the cell phone and data. This economy is talking about all the higher things, does not talk about any human face of that digital economy. So my concern is there may be law to regulate this, there may be law to regulate the privacy and all.
75%.
75%. So there is a huge economy and huge number of people. We should take care of them through any legislation. This is my point in this. Thank you.
Hi, good evening everyone. My name is Smriti and I have recently joined Thomson Reuters as a legal executive over there. Someone brought up the point about use of pen drives and other electronic devices in the official premises. Well, in my office, use of telephones, use of pen drives, use of even data cables is strictly prohibited. Our handbags, no matter if it is a VP or a president of the organization, they are extremely strictly, and you can use any adjective, and they are scanned. Their bags, their briefcases, everything is scanned. We can't take anything outside office. We can't bring anything inside office. So that's about that. We have been talking about training and upgrading the judiciary. But there has been a cyber tribunal. As per my knowledge, there are members to that cyber tribunal, but when was the last chairman of that cyber tribunal? Next point would be that we are proposing to train the seniors and the judiciary, but how many of them are ready to accept that change? How many are ready to get trained? Next point would be that we all are talking about the use of internet. Are we all aware that it's only 1 to 3% of internet that we are using, and rest of it is darknet, which is being used by hackers, terrorists, and other antisocial organizations and individuals. If we remember, there was this WikiLeaks and the this Julian Assange incidents when we all were in the impression that WikiLeaks have been taken a back seat. It has got abandoned of the internet, but it was still available on the dark net. If we talk about the various training videos where the terrorists are being trained, where the very harmful bombs are being I mean, like the videos which train people how the bombs are being made, all those, I would say, threat to security kind of information are available on that darknet. Are we all aware of it? I'm sure most of us are not aware of it. I am very junior in terms of experience of all you people, but that's the only thing that I want to bring up. Thank you.
I just had a quick comment on the technology part. My phone was taken away, my laptop was taken away, my pen drive was taken away, but my Apple Watch is in here. And I just tried to make a call. If I could have made a call, then everything was here. Luckily, it's too far away, but if my phone was outside, it would have caught that signal.
Chandar, that's why the need for training.
And mind you, Chandar, if I'm not wrong, you were always in favor of a paperless office, right?
That's right.
I think even training, when we talk about the training about who? You know, when the investigation case goes to the law enforcement, who does the investigation? Who's the IO? He is probably a sub-inspector level guy who does not even understand what cyber is. Forget about the metro cities. If you go to some of the rural areas, police station, they don't have the computers, they don't have the electricity, forget about the computers or other things. So we have to really look at about the larger picture and the big infrastructure changes.
Please carry on.
My name is Sandeep Beri. I'm a partner with Shardul Amarchand Mangaldas law firm. I don't have much to add. I just wanted to say one thing that, you know, from a sort of a broader perspective, if we look at our history, I think we have always been perceived as a soft state overall, whether, you know, if you look at incidents like some companies threatening to leave India because we did retrospective taxation in certain cases or certain other things, compared with, say, a country like United States where every day you see fines in billions of dollars on various foreign companies and nobody, you know, complains about that. You know, we had a war in 1962 with a country. I wonder if we had a cyber version of that war today, how well we are placed. I think we need to realize that apart from the business and the common man, there are national security implications of the various issues that we are talking about. And I think that's something that has a greater likelihood of waking up the legislators and persuading them to consider bringing about appropriate legislations that we are talking about. The only other thing I want to add in the support of what Sanjay was also saying, that just carrying forward the training and awareness part, I think all of us can do a lot to collaborate with our regulators, the government, the industry, to enable them to understand these issues and find sensible ways of dealing with them. So for example, I think a natural reaction today might be to think that data that's on your premises, you have more control, it's more secure versus cloud, whereas the reality may just be the different, be completely opposite of that. So I think we just need to be open to understanding what the reality is so that then we come up with appropriate legislative response.
I think just to add some data points, but just to add some data points on the cyber war, as per the reports, there was 136% increase in cyber threats and attacks against Indian government organization as compared to the previous year. And similarly, there was 126% increase in attacks targeting financial service organization. In April this year, 2016, it was reported that there is 70% increase in overall cases of cyber attacks. So these are some of the pointers when you talk about the cyber war.
I will be interested to hear everybody and then maybe second round, okay? So please carry on.
Good afternoon. My name is Tarun Krishnakumar. I'm also with Shardul Amarchand Mangaldas. I'm an associate and I work with public policy and technology. So I'd like to start with a question more than a comment. Can anyone tell me what a drone and gold bullion has in common? Anybody at all? A gold bullion.
legislation to control?
Actually, as of April 1st, 2016, if you brought either of these things into India, you need to declare it with customs. And I want to use this as an example to sort of manifest the regulatory responses to new forms of technology. I mean, I think it's a perfect example of a fear mentality where you're seeing new kinds of technology, the government is seeing new kinds of tools coming into the market, and you don't know how to react. So, and it's sort of put into a position where the only reaction is a reaction, and that's not something which is favorable to a lot of people. So just jumping off from there, I'd like to take this opportunity to flag a couple of issues that I feel are very hot today. And Kapil touched upon this. Data breach notification, for me, is one of the largest issues that needs to be addressed today. When we talk about legislative gaps, I think there are three kinds of gaps. One, where the things are not covered at all. Two, where things are inadequately covered. And three, where things are covered under existing regulations. Data breach regulation forms under the first category where it isn't covered at all, and where we need to see some movement as soon as possible. We talk about the Sony hack, the Ashley Madison hack, as if they were, in a different universe. But for all we know, our data has already been breached and is already out there on the darknet, and we just don't know about it. The second issue I'd like to flag is, again, personal privacy. We keep talking about privacy and the SPDI rules. I just think they're too narrow. You need to have a lot more different kinds of information which are covered and considered as sensitive data. Without that happening, I think it's a big problem as far as collection and use of data is concerned. And I mean, we've mentioned the issue of phones not being allowed here a couple of times. I'd like to offer a different perspective on that. So I was recently doing a study on my phone and an Android phone, looking at the different kinds of app permissions that each application asks for when you install it. And basically how it works is when you install an app from the Play Store, it says, this app will use your A, B, C, D. And this could be your camera, your microphone, your contact database, your messages, everything. And in most cases, we just say yes. So for all you know, we could have had a phone here which was recording all we said and we wouldn't know about it. So I think it's a good thing for a change that we don't have a phone, especially when we don't have a robust enough privacy framework to protect against all of the harms it also brings into the room. And lastly, just on a related note, I'd like to touch upon the point of search and seizure. I think this is something which the current framework inadequately covers as far as technology and data stored in the cloud is concerned. We do have quite a robust CRPC, but the provisions aren't followed too well when it comes to technology. The IT Act also has quite a robust framework which we are not seeing the full force of, I would say, yet. Once law enforcement actually realizes what tools it has at its disposal, only then will we see the true extent of search and seizure. And I think there's a huge distinction between physical objects and digital objects. A diary, your personal diary is very different from your mobile phone. A smartphone has way more information than your personal diary. And if that distinction is brought in, I think that then we see a very positive legislative gap being filled. But those are just some issues I wanted to flag at the outset, and I look forward to hearing your thoughts on this. Thank you.
Good afternoon, friends. Myself, Sanjeev Kumar Singh from Mankind Pharma Limited. I'm working with them as a DGM Legal and Company Secretary. So it's been a pleasure to be present here among the fraternity of the wisdom. So I feel I'm here just to learn and listen. So, but fortunately, I have some issues considering my pharmaceutical industry, as I got the initial comments from Mr. Chandar regarding the online sale of Amazon or the various Flipkarts, etc. So I mean, right now, I don't see any law which governs the online sale of the medicines or the healthcare products. Though the government has recently constituted a committee, DTAB, which is taking care for constitution of these laws. So, I mean, if there might be any law which may govern this online selling of the prescription medicines, then definitely a large segment of the Indian population may get the benefit, because if you browse or access the any sites which is offering the online sale of the medicines, they provide the huge discounts like 20%, 30%. So I mean, if you approach any retail outlets or the wholesale outlets, you may not able to get any discount. So I hope if there may any law may be in place which may govern the online sale of the medicines, that would definitely benefit the people of this country. So now with these words, I just pass on to Mr. Sudhisham. Thank you.
Before next person speak, because I am in pharma, so I would like to really add here. There is, medicine sale is guided by Drug and Cosmetic Act. And then there is a Magic Remedy Act. And then there are a few more acts. There is nothing in those acts which talks about online sale, because nobody perceived it that time. The Drug and Cosmetic Act is under amendment, but looking at the Parliament, the way Parliament is behaving, I don't think that it will be passed. It will go back again for the review, so no hope. But can we live without digital helping healthcare? Absolutely no. Because world is grappling with new form of diseases which can be managed well with the help of technology. So if I'm a diabetic, if I'm walking enough using a technology, Fitbit and any app on phone, I'm avoiding diabetes, similarly cardiovascular disease, similarly oncology, similarly stress and psychotic diseases. And when world population is becoming from 3 billion to 5 billion to 7 billion to 11 billion to 13 billion, hospitalization, the hospital and pharmaceutical model is outdated. Okay, so on the one hand, we cannot live without digital and technology helping us. And on another hand, we have huge challenge. So just a quick observation. I don't want to deep dive. I leave it to you.
So will you allow me just a question? Actually, one question came to my mind after listening from you. That's is there any liability for a company who is using the online platform for selling their products? That might be the medicine or healthcare. So I would appreciate and love to learn answer.
We can take it offline. Okay, because I want to listen to everybody, okay? There are many provisions, okay?
I'll have some comments on the farm, some experiences. Hi, good afternoon. I'm Sudhir Sharma. I'm partner with Luthra and Luthra Law Offices. I do arbitration as well as general litigation practice. So some of the points that I wish to raise here have already been taken by my colleagues. The broad areas where we face problems, I think I can categorize into two categories. One is that I personally believe, and this has been an experience, that the cyber laws and the IT laws ought to be in consonance with our civil laws and the criminal laws. They need to carve out additional area, provide for them, and amend the existing laws very clearly. And many a time there's a overlapping, there's a lack of clarity. So that's one area. Another area is that, as everybody pointed out, the landscape is very drastically changing. And as Chandar also just demonstrated to us, that no matter how far the law enforcing agencies go, but there'll still be something which could be new to them to handle. So, and I face this problem because I happen to be involved in one of the foremost and the initial litigation on this point. And believe you me, I had such a tough time in explaining as to what a clip wrap agreement is. And we lost the initial stages because, that was not deemed to be a valid agreement. So such is the nature of the problem that we face and we are likely to face. So my suggestion would be that, the law enforcing agency, be that at the lower level and at the judicial level, I think there ought to be some play in the joints, some discretion ought to be granted with certain checks and balances. And the second suggestion would be that wherever it is deemed necessary and fit, expert opinion ought to be provided for. Because it's one thing not to know something and another thing to feign that you know and then goof up the entire thing. And a lot of problems would be solved if these two suggestions are taken into consideration. So I think, and it does call for some debate on this topic. So with this, I think.
Thank you. Gentlemen, on that side, can I suggest we start from here and then go there? Is that fine with you? Thank you very much. Sir. Yeah, this side, okay.
Good evening. My name is Divya Kesar and I'm a legal practitioner focusing on commercial and international arbitration. I would say that, I more than as a lawyer want to ask questions as citizens of this country. In 1947, when India got her independence, the view was that can we handle democracy? I think we are still today discussing can we handle cyber laws. So I think we are still there. And if you see the enactment came in 2000 and still as a practitioner, first time when I got to know about what cyber laws is or what data protection is when Bazi.com case came. And now, as a practitioner, the most difficulty I face in a court is Section 65B affidavit. So I think these are the things for a lawyer. But what I strongly want to ask, and probably like Mr. Sanjay Kaushik said that, we have to have a passport or some other valid document for creation of an email. But can we securitize or give people the feeling of protection? The data protection is a vital, vital issue because anything and everywhere, for example, in Delhi High Court Bar Association, there is a directory. We give our details, and then you Google it, it's everywhere. So, probably one thing is, yes, it's not too much of an information. It is not a sensitive information, like you said, sensitizing the people. But anything and everything just out there. And like one of the gentlemen said here that what you put on phone, what you download on phone, there are no checks and balances as such. So that is what is more important. I am ready to give whatever information you want. But what does the government provide? What does the law provide? So law, I would say, is still, it actually amounts to total policy paralysis. It's like we need an overhaul of the entire act. Because what is there, and I think majority of the sections, I think Section 66, which went to Supreme Court, a lot is yet to be interpreted. It's like we see, okay, this is not what we do. And this is what we need to do. It's only a handful of people, or probably 2 to 3% who know what they are doing, the commerce, the business. But general people, we are exposed to something which we are not even aware of. So I think these are my points which are very, very burning issues, even as a practitioner or as a citizen of this country. Thank you.
Hi, thanks for inviting me over here. Great to be here and to hear everybody's views. I'm Anupam Sanghi, and I'm generally concerned with the regulatory framework, regulatory and policy framework, focusing on competition regulatory law. I feel that in our system, we don't have, we already have a lot of legislative gaps and everything. Plus, with IT, the problem is that we don't even recognize software as a service business, in the sense there's no specific regulator, there's no framework. So if online pharmacies will be violating because is the pharmacies which are selling online, so there's no system to regulate or to give them recognition, at least, that they can sell. Cab services are also suffering because of this. Flipkart, Snapdeal, all e-commerce is suffering because of this, and they open up FDI. The government opens up FDI, and they say, wow, please come and invest, and ease of doing business, etc. So, but there's so many gaps, and once they invest, and there's so much at stake that there's no way to tackle situations when the competitors, when the traditional businesses, when they're getting hurt or they feel threatened and they come against them, there's no system to, nobody has anticipated that, even though, as policy analysts, people could anticipate it. So I think it's become very important for lawyers, for businesses, when they set up, to do a risk mitigation strategy, to have a regulatory strategy, because they should know that the framework is lacking, and especially when software as a service is not recognized as a separate sector, and the different services that they're offering, they can't go to court and start arguing that, sorry, we are not a taxi service, so we are not going to take a license. It doesn't work that way in our country. So they need to, when they set up up businesses like this, they also need to anticipate, and they need to be ready with their corporate communication, with their engagement with the departments as to what is it that they are going to do and how is it not going to harm, and to have a smoother business strategy. Because otherwise they set up businesses, it's all knee jerk. When they are attacked by competitors or by some department, then they go and fight it out in court, and they're just dragging it. Thank you. Those are my views.
So till the time next person come, when you look at any other than technology, for example, car, there are, you can think of 15, 20 car makers globally, all existing side by side, each one are having 10% or 5% or 2% market share. If you look at technology, particularly social media, there is one Google. Microsoft tried hard through Bing, couldn't succeed. If you look at Facebook, if you look at Twitter, if you look at LinkedIn, they're all one and one. So think about it, the competition challenge it is throwing away.
Hi, I'm Jaya Mandelia. I'm an associate at Singh & Singh Lawrence CT. So there's been a lot of talk about data protection and data sharing. Just one more point. With social media being as large as it's become today, we have a user base ranging from people at the age of 11 and 12 to a much older demographic. I feel there need to be more definition in law with respect to the information that a person shares on a personal account, which may have limited viewership. Can that be used by the government or by public agencies? And can someone be prosecuted for something they have shared on such accounts? Further, apart from there being more legislation on this, there also needs to be more awareness. When you have a younger demographic entering the social media and publishing things, so to speak, they need to be more aware of the consequences of their acts, which is a problem which is being faced not just in this country, but I feel even internationally. That would be all.
I think, Jaya, to summarize your point, it's a question, it's a dichotomy for the government today, how much to protect, how much to intrude. So much of data explosion happening everywhere. They are possibly clueless. Where all do they go and, get into?
Absolutely.
So what's going out of the country and what is being retained there, and how that will be used tomorrow against you.
Next, sir.
Good afternoon. I'm T.N. Tiwari. I've just recently retired as the Additional Secretary from Law Ministry. Actually, this is not my subject. I have been doing convincing work. But it is very interesting to know. Of course, the Government of India had enacted IT Act in 2000 and then amended in 2008. Further rules were made in 2011. But technological development is changing so fast. It is changing every minute by minute. And the way e-commerce is going, we need to have regulators, as many of our earlier speakers have pointed out. We really need, and we have to point out what are the issues where there are inadequate legislation or there is no legislation, or in case there is a breach, how to deal with them. These are some gentleman or lady had spoken earlier also on this. These are very, and this, Mr. Sanjay has really brought out that whenever you are using any, say, ID mail, it must be subject to some verification. And if you go, because the way India is under attack from so many agencies, kind courtesy are not so very friendly neighbors. We have to be very, very cautious. And I was AS, Additional Secretary Parliament for my ministry also. See, it is because of safety of all of us. Unless somebody's background is checked, like when we go to 7 RCR, as an additional secretary, I had to keep my mobile outside. But when I'm officiating, as as law secretary is away or is on leave, when I'm officiating in his place, I have to keep my mobile outside 7 RCR. My car will also be outside 7 RCR. Then a new car is provided from RCR to Panchavati to go and attend. This is all for security. and all of us should be very, very willing to accept, these rigors. And when my secretary goes, he's allowed, his mobile is allowed. But at least I was happy that I had the luxury of walking in 7 RCR or Panchvati. So, now that we have come here, we have to face some difficulties, some inconvenience by keeping our mobile outside. It is for collective security of all of us. Thank you.
Good evening, everybody. My name is Vasundhara. I am an associate at Singh & Singh Lalan Sethi. So as far as cyber security goes, there are so many areas to be dealt with. What's something that I'd like to discuss today is identity theft. It has been discussed by many people before. So I think it is very important for us to have a regulatory body which makes sure that whoever goes online as they are and with the identity that they actually have and not pretend to be someone else. So it is extremely difficult for us to, for example, say you get a call from a telecom company tomorrow saying that you have so much bill pending and you've already paid it and you don't know whether to verify if the person who's calling you is a relevant identity, whether he's actually the authority to be calling you. It's very difficult to trust anyone online these days. The second issue that I think is to be dealt with is e-commerce. E-commerce websites have absolute monopoly today. They can give you valueless product, worthless products. They have many a times packaged stones instead of laptops and delivered it to people. And there are actually complaints like that available on the websites. And the customers just cannot do anything. You can run from one pole to another, and there is nothing, absolutely nothing that you can do. You can probably fight a case, which all of us know takes years to be dealt with. And yeah, it's a very sad state of affairs. So I think these two issues are primarily important to be dealt with and discussed. Thank you.
Okay, good evening, all of you. I'm Dr. Sanjeev Sethi. I'm not a lawyer. I'm the Chief Industry Advisor for IIT Delhi at this point of time and work very deeply in startups and entrepreneurship space. And I think I'm a little amazed and astonished at, I think, the proceedings of this session because I'm doubting how do lawyers practice if there's no actually concrete cyber law. So I'm deliberating in my mind. So are we in safe hands? So that's the question number one. I think the very important point, we had the same issues in entrepreneurship and startup space few years back. And what we proposed, and went to ministry also a couple of times, and what we proposed was, I think, we are addressing two different issues and two pinpointing very specific issues, I think. But the charter, I don't think there's any charter available here. There's no commitment. I think it looks like that who's leading the whole affair of cyberspace. Because we were saying there's a law of land, but now the law of cyber has to emerge because the land is diminishing and is all virtual actually. And there's virtual space, virtual startups, and virtual communication happening on mobile and all that. And obviously the communication. I today will represent only two areas, which is startups. The student community and the entrepreneurs are totally unaware of the laws, and it has to emerge from the point of origin. The point of origin is not very clear about the laws, so they make mistakes. And though they make mistakes, today I think a student or an entrepreneur is not aware what is data, what is information. So there's no segregation. He feels the data is information, information is data. So as basic definitions are not present with me or people whom we mentor, so can I request the body or to create a charter of what we want to address? Can we have a commitment of some sort? Like NASSCOM and the startup community did some efforts to create some charter on IT, this thing. So can we create some charter, and how do we communicate to basic? So points of origins are addressed, that don't mistake these basic definitions. This is the definition. I think the cyber law in corporates is by convenience. I've been 25 years in corporates, including Bharti and Times Group and all. So it's all by convenience. The HR head or the CEO or the chief regulatory officers devise the cyber laws of the company. So if you fetch a data by email, it's fine. But if you the pen drive or you take it by pen drive, it's fine. But if you do email, you're a crime. You're a criminal. So so these are basic stuffs which are not present because the charter is not present, the definitions are not present. So that's my request. Obviously, the e-commerce company is second, and the last one I propose is that e-commerce, there's no exit and entry at this point of time. You can, tomorrow I can go and book a website and start my e-commerce company. There's nobody to regulate me. I can exit it overnight, collecting few crores and disappear. There's no exit barrier to the e-commerce companies, unless you get into a Ministry of Corporate Affairs, register your company, and then otherwise any student can actually create you can block 10 website domain names, start your own company, do offline brick and mortar merger and start a company and do. So why Ministry of Corporate Affairs is not doing such acts, which is, entry and exit of e-commerce, which I'm not able to understand. And so there are few, there are plenty actually. I can talk for hours and hours on, these cyber laws gaps, but I'll request again the 3 C's, which is charter, commitment and communication, and also request that the point of origin through education must be addressed. Please give us few very clear definitions of what is cyber law, and these are the top 300 definitions. As I say, if you have to learn English, you just need to know 300 words, and you actually start learning English, and which I do for people who come from the backward of India, and that's cyber law. If I know the basic 300 words of cyber law, I think I'll make less mistakes, and the judiciary will have, I think, sufficient time to address. And a lot of cases in the judiciary, I can today vouch, are without any basics and without any base. They just come to judiciary for addressing, and which are actually not true cases. As a corporate guy, I can vouch for it, because we don't know what is it all about, and all ignorant because we don't know what is definitions of corporate. Thank you
for raising questions. I'm sure in the second round we will be looking for more solution rather than question that time. Yeah, please.
Just to add to what the Praise said, we would be actually publishing the proceedings of this particular conference and get-together, and we would be making certain recommendations to the government. So after this, you would be sent emails to requesting you for your views. So maybe especially with regard to the amendments and having laws, you can always put in your suggestions, and then they would be circulated.
In fact, taking over from what Salman says, you would see some leading questions on your table. So the answer, what we are wanting is that in case every one of you can individually and collectively come out with, answers to those, that will also act as a great medium for us to highlight to the government and for them to take certain actions.
Good evening, friends. I'm Sikandar Shah from the US Embassy here in New Delhi. So I basically coordinate the US-India ICT and Cyber Cooperation. So there's a lot of activity there. I'm here to listen and understand where the legal issues are. And also kind of what clearly stands out is that cybersecurity, data protection are very important and need to be addressed. Also, the policy imperatives and policies needs to be harmonized with the current sort of market situations and dynamics. And this is also important for the judiciary to understand, and also do a lot of capacity building is required there. This is how I feel. So I'm in a listening mode here. So
aspects.
Yeah.
Thank you.
Good evening. I'm Atul Batra. I'm a practicing lawyer. I'm a partner at Unisof Law Offices. I was just looking at the topic, cyber era. Dr. Sanjeev said he talked about cyber laws. Is there anything cyber defined anywhere in any legislation? What is talked about is the Information and Technology Act. It talks about only something to do with electronics. Cyber is actually something virtual space, a virtual country, a country without any boundaries. It doesn't see any parameters. Where does it originate? Where does it end? The two issues which grip the cyber laws are security and prevention on one aspect, and investigative procedures and linking crime to a person. In both these procedures, I would recommend that there should be a worldwide coming together of a nodal agency, then at a national level agency, trickling down to every police station. And there has to be a lot of education. We talked about 65B. my learned younger colleague on back, she's mentioned about 65B. If you read 65B, it is just a presumption. It is not at all saying that by giving an affidavit under 65B, I will be kind of proving my case. It's just a presumptive affidavit which is actually rebutted. What Sanjay had mentioned about linking it to identity, I would not only limit it to a email ID, but any cyber activity like a WhatsApp, like a film. In Kanhaiya Lal's case, there have been reports that these films have been morphed. So these activities at the first point of investigating team, there should be a regulatory to link it to the first point of origin of these activities. Something like a mobile phone, if a call is made from a mobile phone, then there is a mobile identification number. So this identification number has to be linked. Today, a WhatsApp, if we have upgraded our WhatsApp, it says that this data is encrypted, nobody can access. Apple case in US, the Apple says that will not, despite an order of the court, will not, because of privacy issues, not reveal the contents. We need laws on that. And believe you me, I had a very tough time on the verge of losing a case in court, despite a 65B affidavit, because Google doesn't share the origin of the email, and the court says, I refuse to pass an order asking Google to preserve that email ID or that email for umpteen number of years, as Google is situated in US. So there has to be legislations beyond boundaries of the country. It is not to be limited. I would stop here because we'll deliberate more on it. I have umpteen number of points made. One more thing before I stop. At the point of when I say that investigating procedures, there has to be an education and there has to be separate sections. A structured cyber law investigative team, cyberspace and IPR, cyberspace and consumers, cyberspace and taxes, cyberspace and security issues. Today, even despite the fact that I'm supposed to be one of the tax-savvy advocates in my field, but I don't use an internet banking. I'm still traditional, I'm afraid. So I'll leave it at that. Thank you.
Hi everyone, good afternoon. I'm Shahana Basu. I'm the Chief Legal Officer of Max Group, which includes diversified businesses such as hospitals, life insurance, and other businesses. So from my perspective, I think it's really interesting listening to everyone talk, but I think one of the challenges sitting as a general counsel in a company is that you're always thinking of the business risk. And of course, every CEO is now concerned with cybercrime. Both internally, we talked about employees leaving companies with data, but more importantly, I think also threats from competitors hacking into your systems, which is your threat from the outside. And then it comes to the point of if a breach happens, what do you do, right? Because the knee-jerk reaction is, okay, let's go do the FIR and go to an investigative agency. And that's when you as GC have to sit back and say, no, what are the risks? And going exactly as what Sanjay said before, that you go to an investigative agency who knows nothing about cyber laws, you actually have the greater risk of opening up your databases to people who have no clue. You're actually exposing more information, tying up management time and resources, and the challenges of how that data is going to be used by a government agency is even more worrisome. So unless the threshold of the attack is so high as to actually go file a case, you're never going to do it. So how do GCs get around it? You then think of alternatives, which is you have servers in Iceland where your data privacy controls are greater. You think of how do you create internal systems within the company where your confidentiality and your documents are protected better. But these are, again, responses to a regime where you think that the law is not going to get enforced regardless. So again, back to education and training, investigative arms, and especially as one of our businesses is hospitals, I would like to urge everyone to think about very broadly about the kind of personal information that needs to be protected, and especially health records. I don't think in this country people really realize the sensitivity of information, of health information being out there and being used by multiple agencies in ways we cannot even conceive of. So I think when we think always in terms of financial information, but we need to think more broadly in terms of even health records. Thank you.
Good afternoon, everyone. My name is Mohit Kapoor. I'm heading legal and compliance for Religare, FinWest. Um, Basically, coming from a financial services background, I think we've already thrashed it out quite a bit, and most of the points have already been sort of covered. Just a couple of very quick ones. I think we're trying to tame the ocean today because the amount of technology that is taking our lives over is so, it's like a tsunami right now. So I don't know which, every place you touch there seems to be something that requires to be regulated. Now if you start regulating every single thing, one, you're not going to be able to achieve anything, and two, it's just going to be more of an impediment at every stage. So I think in the context of India, and that also is again a little fuzzy there because there isn't anything called India or not India, and everything is just, the world is just moving at a different pace altogether. I think jurisdictional aspects are very, very critical. Data privacy and security are absolutely paramount. And integration between cross-border, laws, rules, and regulations are definitely the only way that we can actually have some sort of a control over, because everyone will take some protection under some other jurisdiction or something else, and you will not be able to reach out. As it is, even in India, I think everything is sort of either pecuniary, which is very, very feeble, or the penalties are, they're not strong enough, and even if they were, to be able to sort of really arrive at that conclusive stage, it takes years for us to sort of reach there. So irrespective, it's not really a deterrent. Training, I think everyone's already talked about. One last point which I'd like to sort of talk about, which I think Atul already talked about, was the desperate need for an encryption policy. And what should be the framework, parameters, and that could be something that we could use as an immediate step right now. And to all, there would be so many people who are collecting data today, be it telecom, be it health, be it financial services, to name just a few. And how do we sort of regulate all of that stuff? And at least, there should be some sort of a control there as well. Thank you.
Good evening, everyone. Hi, I'm Vikas Bagga, Chartered Accountant by profession. With my background, actually, I'll touch one point that with very less knowledge and almost no framework, we are not able to correlate cyber era with the other things happening around us. So I'll just touch the point number 8, with a small example, that why is it essential for every stakeholder, irrespective of their position and roles in corporate and in IT industry, to have legal knowledge of cyber law and cyber ethics. So we're in cyber era. But when we talk about, we're also in the era of collaboration, joint ventures, sale purchase, and all that. A lot of entrepreneurships are coming up. They're looking to build up their business and then sell it off. They are collaborating and actually beating the big MNCs. But actually, we are able to correlate both of them, cyber plus all these things happening around us. Actually, no. At the time of valuations and other things happening in the business, are we actually giving some point to the cyber system within the business? Actually not. Are we giving some point to the cyber security, to the data security, to the password policy in the business? Actually not. So we can see where we are and what we have in hand. As we are not equipped with the proper policy framework, which can actually help us to correlate the cyber era with the other things happening around us. So that is why I think it is essential for every stakeholder to understand the cyber law and cyber ethics so that we can take the right decision and actually help the society. Okay.
Hi, my name is Kanti Monroski. I'm doing legal practice in corporate laws. What I'm wondering is everybody is trying to over-regulate the industry and business by putting up every question on the way the things are progressing. What we must also realize is that IT and ITES sector flourished because there were less laws, and therefore there were less restrictions. So are we talking over protectionism? And one of the questions here that is written is, are the Indian cyber security policy apply Indian standards and best practices? And that's very interesting because I hear quite a few guys saying that there are no healthcare cyber laws here. There are no hospital cyber laws here. But if you see, most of the data that comes to India in IT and ITES sector is from US and UK, which is relating to their healthcare sector. And what the companies are doing, they are following the standards. So there are no laws even there in US. There are different states, there are no laws, but there are healthcare standards. There is SAS 70 and there are other standards. So what we must realize is that there are certain standards that the industry themselves are following. Who are we to protect here? I also heard somebody telling me that here that there are no e-commerce laws for the healthcare sector. But why do we need it? It's a channel. The healthcare sector already has its laws. The Drug and Cosmetic Acts need to be amended. Do we have a Sales of Goods Act? Why does it need to have a law specific to the channel? Yesterday, RBI has floated a consulting paper on P2P lending. Now, since it did not get anything, is considering those aggregator of services for P2P lending as NBFCs. Now, that to my mind is laughable because all they are doing is making the lenders and the borrowers meet each other. So how do they fall in NBFC? So it may not happen that tomorrow the aggregator of the pharmacist services may be asked to put a pharmacy on the aggregator services. So let's be cautious as to what we are suggesting and using this platform for. Because this is an area where you need to protect the individuals. Likewise, when we are giving our personal data to a email company, they are encrypting it because they want to protect your privacy. The government wants to break that privacy by asking them to encrypt the data. Is that important from an individual perspective? And what standards and the barriers and the restrictions does the government have to ensure that the privacy of the data which is encrypted and provided to the government is safeguarded? I think those are the issues we should look at it. So my thought, number one, let's look at it whether we need cyber laws for the industry, because the more the industry gets regulated, the more difficult it becomes to operate in this country. We already have too many laws. Who do we wish to protect? Are we protecting the national interest or the individual? If it is for the national interest, let's identify which is the data that the national interest requires. And lastly, and most importantly, yes, educate the people. And I heard some people that the judges are not aware of but the Delhi High Court has already done quite a massive work in this direction. If you see, all your M&A filings are now by way of emails, on the computer. So that education is gradually happening. So it's easy to find fault. What I'm saying is, let's not generalize everything and let's pick up the specific areas where the protection is needed. Thank you.
Can I just jump in with a clarification there? Because when I talked about hospitals, I think there's a distinction between health standards in the US and data privacy, which is the US has extremely strong data privacy around health records. You cannot, if you're acquiring a US company, you cannot get any employee data, individual data. It's always aggregate data, and it's always you cannot get individual identifiers. So there is a difference. And I agree with you on your larger point that it's over-regulation.
Bring you a clarification that in US, the data that is secured for the healthcare, and I've worked for a US healthcare company, it's more out of the US standards, and it's not the government regulated law. It is the SAS 70 standard and the HIPAA standards, which have been used by the industry. HIPAA is more important than any law.
Hello, I'm S.K. Johar. I'm retired general manager from NTPC. I have a background in the Electricity Act and electricity regulations, tariff fixation, etc. And presently I'm a practicing energy consultant. As far as this cyber law, I directly don't have any involvement in this. But parallelly, along with this conference, there is a conference going on in Taj Mahal, where another wing of MEA is engaged with the digital BRICS conclave, that's collaboration among the BRICS countries. So there also there is a stress that, the digital is to be the thrust for collaboration. And there also same, topics are being discussed about the compatibility and consistency on cyber laws. But I don't have any further to contribute to this. Thank you.
Good afternoon, everyone. My name is Promita Sen, and I'm from Lex Witness, India's first magazine on legal and corporate affairs. So as media, I'm here primarily to listen, observe, and report. But just as a layman, my primary takeaway would be the security aspect, because most of the platforms that we share our data on, whether it's over email or whether it's online Facebook or even do business on, are on an international platform. So I agree with some of the speakers who mentioned over here that we need to have laws that are on a globalized standards and maintain that consistency. Speaking of consistency, someone also mentioned about the taxation aspects of doing business online. For example, WhatsApp, there are very small businesses which conduct majority of their businesses over WhatsApp. What is the tax regulations on there? Why are we only taxing when it's e-commerce industry? So if there has to be laws, might as well make them consistent all across. Those were my 2 cents. Thanks.
Before you start, sir, you have some observation.
I also wanted to say that somebody mentioned that Flipkart has recently faced problems for entry tax. Well, in some of the states it has been stayed because, again, entry tax was levied because of the state laws and not on the e-commerce platforms. So again, I'm trying to make a distinction that let's understand the channel and the industry and the law specifically. Also on Sanjay, on your point on giving evidence on emails, what we also need to understand is that these email companies are probably incorporated overseas. So how will they recognize the proof that that you provide? And in any case, impersonation is a crime in India. So I think that can get covered again under the existing laws of India. Yes, it is very important to have a body which coordinates its words. Like recently we faced that here was an Indian company which gave some data to a US company which was infringed in Africa. So where do you control and where do you take the enforcement action? So the word coordinated body is a good solution to look at it, but over-regulation or providing proofs for emails is something that we should be careful about. Thank you.
Please go ahead.
Good afternoon, everybody. I am Nirupam Srivastav. I'm Director Strategy and M&A for LexisNexis, one of the leading legal solution providers. By qualification, I'm also an engineer in engineering and electronics and communication, and I'm a company secretary. So, so these two things pull me in very different directions. Infosys, Narayan Murthy took 3.5 years to get his first computer into India. And then he started serving his US clients. And then when the Narasimha Rao came and he liberalized, IT industry boom happened. So when we look at IT industry, it's very important to understand it happened because of relaxed regulation. And not only in India, even in US. I've worked in Silicon Valley in India and in US. And I see, the kind of innovation or the energy that comes with the relaxed regulation around technology, around innovation. That's very, very critical. And the question I ask back is, why do not we have these companies in India? For example, Mr. Lal talked about so much money going to Google outside India. Why don't we have a Google-like search engine in India? In China, for example, they have Baidu. Baidu is their de facto Google. It's not Google. It's Baidu. So everybody goes there, searches on Baidu. We don't have it because we did not create an encouraging entrepreneurial framework. And that's where the need was. Same example I talked about, Sanjay talked about the email. If we have passport-based or some genuine authentication around passport and checking if we get an email. So let me counter question. So we all have mobile phones. Airtel and BSNL came at the same time with the mobile phone SIM device. How many of us have SIMs from BSNL? Nobody, because they asked the same thing. They said, give us your rent agreement, everything, and then only we will give. And people said, Airtel is giving me on my home, I don't care your BSNL SIM. And even then, you cannot fight cyberspace with a real space. You can have a passport validation, but I can still spoof your email ID, like the example she gave, I mean, Prime Minister is a pretty valid example. I can still spoof your email ID with is a technology. So you can control this through technology only. So you have a digital signature, you have other protections around that. You can't have a physical security trying to build it into cyberspace. It doesn't work. So we all need to understand technology from that perspective. Then only we can manage technology. We cannot manage technology. And same other example, the Apple versus FBI. We are all global. Nationalistic laws won't work. I mean, nationalistic laws are, failure from the beginning. So assuming the US government or US court in the scenario in FBI versus Apple had said, Apple, you have to give data to FBI no matter what. Imagine what would have happened to Apple sales around the world. Or even in US, for that matter, US citizens would be very scared to buy Apple phone because their all data is going to US government. So nationalistic laws won't work. We have to see a global market. We are in a global market. Indian companies are selling abroad. We are consuming globally products. So all the cyber laws have to be defined from a global perspective. Otherwise, it's a failure from the beginning. So that's 3 points from me. Thank you.
Sure. Good evening. My name is Apar Gupta. I'm in private practice. A part of my practice also includes policy advisory for companies. Just 3 quick points since I'm at the end. The first is that a lot of people have cited anecdotal examples, sector-specific examples. I think it needs to be discussed in an institutional framework. The Law Commission of India has till now not organized a larger consultation. Of course, sector-specific concerns will arise even beyond it, and I think existing law can take care of it within its existing framework. The second is that when we look at the law, let us not only look at the substantive deficiency, let's also look at the procedure. One of the key reasons the IT Act has been ineffective has been because the civil remedies have to be adjudicated by a person called an adjudicating officer, which is an IT secretary, not trained in law, not having a permanent seat, and thereby being not institutionally equipped to deal with matters which arise under it. The second is that the appellate tribunal has not been constituted for more than 3.5 years. It's now shifting from the Jeevan Vihar Winding to some place in Rohini. The third point is that a lot of our problems which we are discussing today are not cyber law problems, they are rule of law problems. For instance, pendency in courts. The entry tax matter has been referred by the Supreme Court of 5-judge bench strength by Justice Kapadia in 2010 to appropriate strength. It's still not been decided. So when your Uttarakhand writ is filed, when a levy is put on Flipkart, it will eventually travel to the Supreme Court, an interim direction will be given, and that will govern it for a long period of time. Law will not be clear in the interim, and that is why there will be a large amount of concern which arises in industry. What is the nature of this problem? It is pendency in courts. It's a rule of law problem. It's not a cyber law problem. The same issue we also see with Parliament. Executive notifications, for instance, you have a provision under the IT Act for encryption, but encryption standards have not been made till now. Finally, I would like to say that even when you look at how the police is reacting, it can be attributed to police apathy, lack of training. These are all rule of law problems which go back to police reforms. So let's be limited at what we are looking at. The first thing is that any such conversation has to be within an institutional framework. I would suggest we make recommendations that the Law Commission takes it up. Secondly, procedure is important. We need to be as close to the courts which work well and take those practices forward. And the third is a lot of the problems are rule of law problems. Thank you.
Thank you. You brought another side of the story, but a good one. Please carry on.
Hi, my name is Sagar and I'm from Value First Digital Media. So I'm taking care of legal and compliance affairs. So it's very little to say because everybody has captured almost all the topics. So as far as legislative framework is concerned, I see that the IT Act has covered almost all the perspectives. But the difference is that there is less specificity and there is a lot of vagueness. The vagueness has to be removed, and it is need of the hour that we clarify things very precisely. Although we see that for in developed countries, like we have clauses, they have complete acts related to those clauses only. So there are some gaps that we can bridge. So like sub-delegation is done at a high level in the IT Act. So a lot of things have been delegated to government. So therefore, there are delays, like my friend rightly said, the adjudicating authority, the tribunal, and what we should do is we should incorporate some exclusive judicial body which should be exclusive to cyber laws only. So all the matters that are related to cyber laws can be dealt with by that judicial authority exclusively. Second thing is certification providers. So in the area of data security, so I see that the certification providers, ISO 27001 is a very important standard. So it relates to information security, but the certification authorities are you can buy a ISO 27001 for like 1 lakh rupees. It's very easily available in market. So there should be some regulation that should apply on certification authorities. And data retention is also, which has not been clarified. In many industries we see that there are no timelines prescribed for which a corporate should retain a data. So the data are held by, for example, RTI application was moved for CDRs in the telecom sector. So Sanjeev would be the right person who could, testify this. So from BSNL it was sought that for how long do you retain data? So it actually the answer was maybe for a year, maybe for 3 years also, wherein it is not required to retain a call detail record for 3 years, although BSNL is doing that, and that retention is being outsourced to a service provider, and that service provider is a ISO 27001 certified, and there could be a possibility he could have bought that certification from a certifying agency, which is not at all regulated through legislation. So and identity verification of the originator is also a concern. So the instant example of this dispute between Hrithik Roshan and Kangana Ranaut, so some identity theft has happened, and it is still difficult to trace out who has done it. So there should be some international treaties on information sharing which could actually allow all the countries to exchange the information freely, so that enforcement could happen. And our conventional judiciary is actually not well equipped. So that's why exclusive judiciary is very important, and the exclusive judiciary, the qualifications, that needs to be given a deep thought, so that they are aware about what cyber trends are. So and regarding e-contracts, so in India the concept of e-contracts is very unaccepted. So I haven't seen companies doing e-contracts. So one of the reasons is there's no confidence in legislation. So there should be more robust provisions related to e-contracts, so that corporates can move forward and sign contracts on the internet, or maybe exchange on emails, rather than printing them, signing them, and sending over the couriers and other modes. So I think that's it for the moment. Thank you.
Thank you. Before the next person is start, what I intend to do is, we raised a lot of questions, a lot of problems. I will go around again, and anybody who has some solution to add, please feel free to add. So let two gentlemen finish, and then I will going. Ram, I will start with you.
Hello, good evening everyone. My name is Rupesh Chandra Madhav. I am writing my dissertation on privacy law, so I am here to learn. I don't have to add anything. Thank you.
Hi, good evening all of you. Myself, Abhinav Mishra. I am from the School of Law, Sharda University, Assistant Professor there. I am working on a project related to the critical information infrastructure protection. Now, summing it all, I would say that cyber era is definitely an era in which everything needs to be done in a cyber way, and definitely the jurisprudence as well. That is the jurisprudence of the lawmaking, and the lawmaking should also be done in such a way which would not only be the jurisprudence 2.0, which is the inclusive way of making the law, but also we should move towards the second step, that is the cyber legisprudence, which means that the lawmakers should know all about the cyber. And I would define the cyber legisprudence in my own way, keeping up the 2 points, out of which the one would be that understanding. The first one, that the understanding of the cyber events or the cyber things and their impacts and the effects or the consequences, by which they would be able to frame more and the better laws. And the second thing would be that they should make such laws that should go hand in hand and at the time which they are needed. For example, we couldn't get this encryption policy till yet. Now, whatever the encryption laws are talking about, these 56-bit encryption, where right now we are working on a 512-bit the encryption. Now that's very obsolete, certainly. Now coming on to the second part, that is the risk mitigation portion, where these critical information infrastructure policy are to be discussed. There we can also think of such critical information infrastructure policy in which the sectors are to be decided, and the 3 areas which I have taken into consideration are the one, the determination portion. The India hasn't very bad about it. India has not even determined its computer networks, which are said to be the CII part. Now the second thing is the procedures to be followed. We haven't even made up the procedures to be followed to protect our critical information infrastructure. The only NCERT is there, which is only working over the protection and the notification, except that we don't have any other thing. Now look towards the US. The US has created its own homeland security. They have already determined the sectors in which they have to work and what are coming within the debilitating, impacting sectors such as the electricity and all the information infrastructure. And within that homeland department, they have their own policies, the procedural policies to which the citizens and the interaction is also to be needed. And then the last thing is judicial approach. Now, even in the judiciary approach, I've seen only the one case, and which is not the case exactly regarding the CIIP. Rather, they have gone altogether towards the software and protection part. And that's why even the judgment, which was from the Kerala High Court, they said that yes, the copyright protection can be given to them, but not this CIIP protection. So thank you for that. The only comparative aspect which I would say that the US has done well in the CIIP, and we should take lead from them as well. Thank you.
So in the next round, solution, anybody who has solution, please.
Thank you. So I did come prepared with solutions, because that's what is the ultimate aim. Before that, a 30-second teaser. By the year 2020, the overall devices as against the actual users will be outnumbering by 6:1. Number one. Secondly, worldwide, there is a talent shortage of people from this area, which is close to a staggering 2 million. Having said that, I am fortunate to have read this article before coming here by M.K. Narayanan, former National Security Advisor. I thought this would be the best way of summing it up. So I've got 10 points out of his own article. These are not mine, but for the benefit of everybody. How to secure cyber threat. What he suggests, number one, bleeding edge technology, along with big data analytics. He goes on to say, customized approach to specific challenges and a radically new system and data protection architecture that could turn asymmetry on its head. Third, change in attitude of users of systems. Fourth, proactive approach to investment in hardening systems. Fifth, better training in computer security practices. Number 6, careful engineering of things to be connected to networks. Number 7, policy formulation supported by a legal framework. Number 8, crisis responsiveness. Number 9, India can take leaf out of China. It has announced plans for comprehensive digital surveillance. They are emphasizing on cloud computing techniques. With involvement of its Ministry of State Security, India could be a potential target. Number 10 in nutshell, India needs to be forearmed with both, and I like this sentence, with both offensive cyber operations and strengthened cyber security. So I think this is possibly the need of the hour. And since he has written it in the editorial column of Hindu, I thought it makes sense to share it with all of you. Thank you.
Tabriz, I will re-emphasize on the word coordinating body, because internet being a globally used platform and the offenses could come from anywhere. If our suggestions could be, and actually many countries are working towards that direction, that if there could be a word body which coordinates the cyber security. That's
Something like parallel to certain kind of thing. What kind of regulatory body you are suggesting? Sorry.
It's a standards body. It's a
Standard body. Okay, makes sense. Yeah, yeah.
I mentioned about the nodal agency at the world level and the country level. It should not only put a standard, but also be controlling authority. I differ with my learned friend who had mentioned about the disagreement with me on the FBI versus the Apple case. The business or the business policy should not be ever taking a priority over the laws of the land or the laws or the security related issues. It can never be a case. It should never be a case. Such like practices or policies, be it harming the business interest of a business entity, because it's business entity versus the security, it should never ever be allowed. So that body should be able to regulate over such issues or ban that business entity to do further business. So a worldwide body, and also I mentioned about identity linked to every electronic or a cyber linked activity. Identity to a person, like Sanjay Kaushik had mentioned about identity to email ID, but it should be identity linked, be it a Google account, be it in USA. But once we open a Google account here, it should be, should be regulated by the laws of the country. And a country-specific law should be linked. It should be able to link it to the pinpoint head.
Couple of points.
I just wanted to.
Sorry.
So go ahead, please.
Please. Just wanted to add a couple of points with regard to an international nodal agency. In fact, there are already agencies working in that direction, both from a practical perspective with regard to enforcement, as well as from a regulatory perspective. There is already an intergovernmental body that is actually framing or trying to sort of frame international law on cyber aspects and cybercrime. More on the lines of under the aegis of the United Nations. On the practical or the enforcement side, Interpol actually has a separate setup and a division which takes care of enforcement with specific regard to cyber. And that also coordinates with different government agencies internationally in terms of identifying international crimes and across multi-jurisdictions. So that's just a point that I wanted to add there.
Thank you. Couple of points. Some I'm just trying to coordinate. First of all, I would like to very humbly not agree with you as far as HIPAA is concerned. HIPAA is an act, and they have certain standards that are accepted under the act. So, which brings me to say that it is legislation. It has been legislated in United States of America, and it maintains very carefully health records as well as the employee data and information of those who are in the health industry. I'm sure the Honorable Chair will let you intervene at the right moment. Thank you. I don't have the power. So the point is, number one. Number two, as we look into the issues, there was a point which was a contradictory point which was raised as to the business interest and the interest of national security. In that, I think that every sovereign would have the right to look into how lawful interception is allowed. Whether there would be a fault in lawful interception, whether if your statute says these are the people who can lawfully intercept, whether that is followed or not, whether there are breaches, that's a process issue. I think one of my friends there had mentioned about the process issues. But I think for national security, lawful interception is required. Now, coming into solutions, I cannot, my very esteemed colleague, secretary, the chair of one of the sections of INBA, Mr. Ramaswamy mentioned about, or rather quoted, cited quite a number of solutions that was already in the Hindu. One thing which is essential, I started with the handling of the big data, which covers all of them. And then I related that to cloud because we are all going to cloud. So we need encryption policy urgently. We need the cloud computing policy follow it up because cloud is a nodal place from where there would be breaches. Then coming into when we have so many agencies, as he said, that we do not need too many new laws, I think I would definitely agree with you. I will absolutely end with an agreement. So the point is, what we need is coordination, which is lacking. And there, if you look into global practices, we might need to look into Europe. And there, I would say that please look into the cyber coordination across the EU members when they have come in, many of them, 29, I believe, and then maybe draw on that instead of copying from any other jurisdiction directly, take in a sense from these global best practices and make something where the with due respect, Ministry of External Affairs also knows what Ministry of Home Affairs is doing.
Thank you. If there is any observation, yeah, please go ahead.
First of all, yes, I do stand corrected. HIPAA is an act, but HIPAA is based out of on SAS 70. And my whole thought was that you can take up industry standards and work on those rather than. The second point is, I do agree that there has to be a national interest, but at the same time, you have to keep the personal privacy policy, and there has to be balancing between encryption, the database shifting, the data security, and the national interest. These four are the critical arms, and I think we get swayed by each.
Yeah, please.
I think one of the point which has been mentioned a couple of times on the email identifications, a couple of you had mentioned that. And I think I totally agree with you. All the points which you mentioned is a procedural issue. It's not about whether it should be done or not. It's all about procedural issue. Whether the documents given there will be secured or not. So are you really saying that the communication which you're doing on email, you're doing without thinking that that is secured? All the email servers, they claim to be the most secured ones, whether it's Gmail, Yahoo, or anyone else. Nobody says that. And everybody has a legal liability to keep your identification very, very secure. Second point was about these are the foreign companies. But most of these companies have an office in India. And when it comes about encryption or taking the interception of all these, I think law enforcement has a very good role to play. And we have seen in the cases of even WhatsApp, when the case of this betting scandal of cricket was done, even the WhatsApp of a couple of players and the people involved was intercepted and all the messages were there with the law enforcement. So law enforcement does have that powers and they have the ways and processes to get through that. Impersonation was point which I think you made out, that impersonation is it's already punishable. But issue comes when you identify the person who has impersonated. If the person has created an email ID without leaving anything back at it, or the servers for which he is using is in Germany or somewhere, getting information from there is very, very tedious and it's very difficult. So I think that's procedural issues, but I strongly feel that when a person is creating an email ID, some kind of identification, some kind of linkage has to be there on that.
Yeah, I mean, while we discuss how to legislate on the internet, I do want to mention that the benefit of the internet was really to be not very regulated. And if you look at the pharmaceutical industry, because of weak patent laws, we could make generic drugs in India, and those generic drugs could be exported to every country through websites, hiding behind websites which were not identifiable. I've had many clients who've tried to stop that, and it didn't happen. So it actually benefited a number of pharmaceutical companies who set up these websites and sold. So the internet, and China is a classic example of using the internet to your benefit rather than aping laws of another country. Internet laws require very strong IT infrastructures. The biggest beneficiaries of strong internet laws will be the countries which have strong IT networks. When you talk of .com, it's all in the United States. Therefore, they own that data. It's not even within your four corners of your country. Data of Indians is sitting in the United States of America. We will be governed by their laws. Apple case will decide whether Apple will give you that data or not. We need to be very mindful of this one basic fact. Therefore, the internet can be a huge benefit, and especially for a country like India, where you can hide behind, and China has used that very, very well, that let's not say that you have to have very strong laws. No, we will not allow Google to come into China. We will have our own Google, and we will monitor that, and we'll develop our own IT infrastructure and then legislate and then dictate the world, and that's the way forward. That's one point. The other point that I wanted to say, so internet is really very dependent on a laissez-faire. That's the other important factor, that you have to let the technology develop. If you legislate before the technology itself has developed, you have a problem. So my Apple Watch example is that today your security agencies now need to be told to look at watches more than a pen drive. Obviously, this is more harmful because it transmits and receives, whereas my pen drive doesn't. That training hasn't been done, but if we were to legislate on watches before the Apple Watch came, the Apple Watch should never have come. Everybody taking their watches off. So what comes first is important. The other aspect is that we do have the benefit of not having a strong IT infrastructure. And we do have the benefit of the United States of America having a very strong IT infrastructure, and users of the IT infrastructure for over a decade previous to us. And it's a very heavily legislated country. So there are lots of good examples which can be picked up, not just from, and unfortunately again my laptop is not here, but I made a listing of all those, that I picked up examples from the US, Europe, Australia, Canada, which can be looked into. And I think this needs to be, you need to sit down with the businesses who run those businesses, and then see whether those legislations can be adopted here or not adopted here, and in fact broken, so that you can then develop that business. There's nothing wrong with that. Every country in the world has done that, and I don't see why we don't seem to be even thinking on those lines, and we strongly say, no, we must legislate rather quickly. I did take an example of multi-brand retail. It's a joke that we are still talking of not allowing multi-brand retail to be set up. Amazon is already here. That's your biggest multi-brand retail. Cab aggregation. We were trying to still public transport, and cab aggregation became, came in, and now we're trying to legislate cab aggregation. I mean, it's a whole different business model which ought to have been allowed to develop, and then looked into the problems that it faces, and then see where you need to legislate on that. One very critical, I think we can save a lot of sort of environment and be paperless office. The General Clauses Act still has a very broad, and the General Clauses Act impacts a lot of other acts. It says that delivery of most documents by post means by registered post. And by post is in numerous legislations around the country. And we were having this very interesting conversation at the trademark registry for sending official examination reports, which it still had to dispatch by post, which costs maybe 6 rupees a registered post AD, plus the administrative effort of printing a letter, putting it in an envelope, posting it. There was no provision in the Trademarks Act even today for delivering these letters through email. So we as a body said, why don't we do this informally? There are so many such acts which are just sitting, and Mr. Modi did mention that please remove all these archaic laws. This one change, that by post means by email, could save the nation so much of administrative headaches. And emails are not that anonymous. Emails are very trackable, and emails do get tracked when agencies want to track them. There is nothing in the cyber world which is hidden. They are quite easily trackable, as I'm sure you will agree with that. It sometimes is difficult, but it is trackable. So let's not think that it's all very anonymous and therefore a very dangerous territory. No, it exists. People in cyberspace exist, and they are identifiable people. Monies change hands. They are identifiable. Of course, bitcoins is the next sort of currency going forward, but they are very identifiable. And good investigation agencies will track it down for you. So I don't think we should be that scared of the internet. So we need to be a little careful in how we go about it. Let the technology develop and let the laws follow, but not too far behind, but very closely behind.
So just to, on lighter note, on Chandar's problem. So I was watching, so, there is a startup which has first time demonstrated augmented reality. Okay, so at the back end there is a heavy end server and heavy technology, but at the front end there is a small device. Using that, they create augmented reality in the room. Okay, and depending upon what kind of content they have at the back end, it could be anything. They can take you to anywhere in the world. They can present you any data. They can bring any personality, Obama standing here and talking. Okay, so based on the content they have, so it will be a small device. So next time you will be carrying a small device here, and without a screen you will be doing augmented.
Might not even have to be here with that kind of technology.
Yeah, Ram should
I think I have
conduct
one
the
more,
webinar next time so that Mr.
And the valuation, and the valuation of the company was $3 billion without any demonstration. They have done the demonstration, and now a few weeks back, and the valuation will be something like $30–40 billion overnight. Yeah, please.
Yeah.
So
I
I just
have
wanted,
just one small
Sure.
request. I think you were talking too much about your presentation. If INBA thanks, you can pass on the presentation to, and that can be, can be, thanks.
So actually from what Chandar said, I really want to add, and I totally agree with him. This is a problem that we are trying to legislate, or we are trying to find, what service cab aggregators are into, and online pharmacies. Although it's all on the cloud, so we need to recognize e-commerce sector, because Amazon is here, and we multi-brand retail is already happening, and the traditional players are threatened. But if we recognize software as a service or e-commerce sector separately, that they can deliver on the cloud as opposed to on physical outlets, then there should be less confusion, and their competitors are not these traditional guys. Actually, their competitors are new solutions that can come up very quickly. And if somebody is here from Home Affairs, I just wanted to also add that how US created the Homeland Securities after 9/11. And somebody mentioned about IT Act and the lack of rule of law, which Apar Gupta mentioned. It's really the enforcement which is going to help by departments getting connected, which the US Homeland Security did. All the departments are connected IT by IT infrastructure, and that's how they could really get all the data information that they, and then those guys which came on the boat in Colaba and attacked Bombay could have been avoided if we have, very good intelligence and IT infrastructure which connects all the departments like the US Homeland Security does.
Just again to add here to what you were saying, fortunately or unfortunately, I've been involved with some of the work with a few national security agencies. So there is already a system in place where they are already sharing information. There is a national cyber command which is being already put in place in India. So hopefully maybe 5 years down the line, we might have a situation where a central command would be there to coordinate, especially with regard to cyber activities.
I had read about that a
Yeah.
few years back, and now it's 5 years more. So yeah, maybe
Hopefully.
it takes a decade to do this.
Yeah, just one more point to add actually. I'm emanating from what we are discussing about over-regulation. Are we really talking about over-regulation here? Because we are only talking about the laws that we already have. Those laws are required to be amended to be able to take care of the needs that are existing in today's time and to be able to cater to the world level, and if we are able to equip ourselves to the global requirement. And probably that is what is required even when we are talking about amendment to the General Clauses Act or to the amendment to the CPC. Probably the only simple solutions are to add the term email instead of registered post to be insisted upon. So that was one part. And second is that it is also about data protection that we are talking about here, and the privacy, which is not inbuilt at the moment in the IT Act comprehensively. So these are probably the two things which we need to work on a little more when we are talking about the legislative requirement here.
Tax perspective, the challenge for all the revenue authorities across the globe has been in an e-commerce model to identify the situs of the sale and identify the taxpayer. So for example, will it be the aggregator, will it be the vendor, or will it be the customer from whom they will be able to recover taxes? And OECD has been so far appearing to be reaching on a consensus that looking at the speed at which money travels in an e-commerce atmosphere, it is the end customer from which they can probably recover taxes. And that's another aspect, that's another challenge, that in terms of identifying the situs of the sale, the execution of contract through an electronic mode still remains a challenge. Thank you.
I did want to share a very interesting example of legislation versus allowing. Look at the film industry. And I assume everybody here is familiar with the Shreya Singhal case. So the Shreya Singhal case, the Supreme Court said that as an intermediary, they're not supposed to remove content unless there's a body, a government body or a court order asking them to remove. So I could shoot a film on my phone, which is the unorganized sector. So I could be shooting an objectionable film and putting it on the net, which would be visible to everybody in the country and abroad, and nobody would be able to do anything unless they went to court. The legitimate film industry still has to go to the censor board and get cuts for simple abuse words. I could put porn up and nobody can stop it till somebody goes to court, whereas the legitimate industry still has to run it in a screen, in a theater, has to go to the censor board. That's where our laws, I think we've just not woken up to the reality of the internet. And this is one very classic example of the internet versus where our minds are and where we are today.
So I think if we don't have any other solution to add, I will request Salman to sum it up.
Thank you, Tabriz. Just to quickly sum it up, it's been a very interesting session and excellent points raised, and also equally excellent and informative solutions that have been highlighted. I'll just quickly sum it up, trying to sort of summarize some of the major points that we discussed. Of course, we'll be covering it up again in the report that we are bringing out and the suggestions that we are making to the government. So Chandar set up the tone with very valid points with highlighting the services sector, and also about the fact that India has leapfrogged the revolution, the IT revolution. He kind of later, of course, subsequently when he talked about the IT sector and the fact that technology or law is always catching up with technology, or law should catch up with technology rather than the other way around. And that's very valid. That is what I think has made India what it is today. Had we probably enacted a IT Act maybe before the early 90s, we wouldn't have been an international superpower. But at the same time, I personally feel that we probably need to have a proper information technology legislation, because as many of you would know, The IT Act, when it was originally introduced in the Parliament, or the bill, was actually an e-commerce legislation. So even if you read it today, the preamble of the IT Act talks about an act to enable electronic commerce and to give recognition to electronic signatures. And that is the sad irony of the legislation or the whole regulation around information technology law in India. The fact is that there was a legislation, it had a specific purpose to enable electronic commerce, has been used or we are trying to use it to regulate the whole of cyber law, which is completely a different animal altogether. And unfortunately, for us as a country, even though we've had various instances and situations, we've also introduced amendments in the Act. We have not been able to overcome the lacuna that was there originally. If you would remember, when the amendments were actually introduced, I would say it was more of a knee-jerk reaction to a lot of situations that had arisen, mainly around the outsourcing sector. And those amendments were still not able to cater to what we were really expecting from the IT Act. It had to be an Information Technology Act, not only looking after e-commerce or data privacy or cybercrime, but also the overall gamut of the whole cyber legislation, which it fails to do even today. The amendments were they were actually, the incidents when the amendments were introduced, there were 10 amendments in different legislations that were passed within a matter of 14 minutes. So there was no debate about it. Unfortunately, we are sitting in this honorable parliament, but that's how things work in this country. My humble submission had been, in fact, I had made this earlier also, that as a country and as a society, we not only need to amend laws and make legislations and bring about enforcement, we actually need to develop a culture for information technology, culture for e-commerce, culture for cyber law. Because unless and until we, as a society, develop that culture of appreciation of how information has to be handled, whether we have an act or we don't have a legislation to regulate data security or data privacy, we would still land up in the same place. That goes very much to what Sanjay said about cybercrime and jurisdiction and about the training aspect. Because again, it is something procedural. It is relating to the fact that we appreciate and our officers are trained enough to understand what is sensitive data, what is not sensitive, whether my telephone number is sensitive or not, whether my bank account number is sensitive or not. That is something that is to be informed to them, that they have to be trained about. And not only them, I think we as individuals also, as citizens also, we need to be concerned about that. So for a long time, even after the amendments, when we had the original amendments to Section 43, Section 43A, we did not define what is sensitive personal information. It was only subsequently when we brought about the rules now that what is sensitive personal information has been defined. So we can't even blame those police officers who have probably had very limited exposure to this. Because the educated individuals, even the parliament, the legislature has not actually enacted the relevant laws. Now, once you don't define what is so critical, how you expect an enforcement officer to actually take action? So moving on, there were a couple of other points that were highlighted, and as I mentioned, data security and data privacy is a huge, huge topic, whether it's from an industry perspective, from practical perspective, or from a legislative perspective, and as rightly pointed out by various individuals and discussants, I think we really need to have a separate legislation on that particular aspect, and probably we might seek inspiration from Europe because they have had a very strong privacy regime. And as Kapil rightly pointed out, it's now already, we are way away from the EU data protection law. It's now privacy shield that we are talking about. It's now a separate legislation that we are talking about. Moving on, again, jurisdiction and cybercrime identification is another major challenge. We unfortunately are not in a position to pinpoint in situations of cyber instances where the attack originated. Sometimes, I've been shared examples where during the Commonwealth Games, India was attacked almost, India received, Indian government organizations received almost 20 million cyber attacks. It was only the fact that our agencies were well prepared in advance that they were able to repel them. So again, it's not that we are not capable enough. It's just that we probably need to streamline more things. Encryption again came up as a major topic during the discussions. It was expressed and discussed about. Interesting fact that I wanted to share about encryption is that though it is so essential to privacy, in our country, India has a unique distinction in the world to prescribe the minimum level of encryption. I mean, everywhere else, they prescribe the maximum level that you can use. In India, we do that minimum level. So we have obligated people who are trying to use encryption, if they use it more than 40-bit encryption, if you want to use more than 40-bit encryption, you have to take special permission from the government. You have to inform the DOT, while it's the other way around in the world. And our own laws, there are different laws that talk about different levels of encryption. For example, the license agreement with the Department of Telecommunications actually obliges you to use, not to use more than 40-bit. If you do, you have to take specific permission. The RBI prescribes 256-bit as the minimum level of encryption. Then the IT Act talks about 512-bit. It also talks about some higher levels of encryption, but primarily from the perspective of the certifying authorities. So it has not actually per se talked about the highest level of encryption or any particular level of encryption that is to be followed. Now, the WhatsApp incidents or the Apple FBI controversy, I think we've had fair share of that within India, and unfortunately there has not been clarity. But we had these instances about BlackBerry a few years ago where, ultimately our agencies prevailed. As a country, we prevailed on BlackBerry. Today, BlackBerry has its mirror servers in India, while initially they were very hell-bent upon not having such servers anywhere outside the United States, or Canada for that matter. So finally, that kind of brings us to the whole debate about national security and cyber war, and the fact that whether individual privacy should prevail over national security concerns. And I think all of us would agree that it is national security that should prevail. And ultimately, if you have situations like WhatsApp encryption, end-to-end encryption, or the Apple FBI controversy, probably in our country we would want the governments to have access to such information in certain situations. So that's kind of summing it up, and I would just like to thank everybody for sort of coming over and for making this discussion such a success. Just before I conclude, I wanted to sort of announce that INBA is actually taking a delegation to the UK in June, and this delegation would be there to specifically campaign for Make in India program. Information about this delegation and how you can be part of it is going to be available with Archana from INBA and of course Nachiket here. So would request all those who are interested to please collect some of the information brochures that are available here. Thank you once again.
Thanks, Salman. Our guest couldn't turn up because of the activity in Parliament which is going on, and we understand. Nachiket worked hard to bring them in.
Meenakshi Lekhi is coming. She is coming within 5-10 minutes.
Okay, excellent. So Nachiket has been working very hard on this, and we selected Venu also because of that. It will be easy for them to walk in here. Even if some of them didn't turn up, don't take it too hard on you. So let's go to book launch now, and wait.
Since Mrs. Meenakshi Lekhi is coming, let's possibly wait.
Okay.
In case I can just.
Sure. So in the meantime, why don't we talk about the books?
Yeah, in fact, before I talk about the book, I think it will be completely right on my part to possibly the man behind the show, since he is not here. Maybe a round of applause to Mr. Kaviraj Singh, who has actually made this happen, not for the first time, but for the second time. And we all know, how he has used his channel. Of course, Nachiket, along with you. But the fact is, since he's present, not here, but omnipresent, he is here, and I think it's my duty to announce that, a lot of work has gone by him. Second is, I like to call here Suman also. And many of you don't know that he is actually the one who has helped us out with bringing out this book, which we'll be officially launching February 11 to be precise, is when we had the roundtable discussion on how to make India an arbitration hub out here. We got some phenomenal response from people across the globe, and most of them have found their way out here. And Suman, I think kudos to you for the way you have conceptualized this book. I think it's going to set a new trend, and more for the content part rather than the glamour part. And so I thought, it's in fitness of things that it should be. There are certain people who are unseen, but you should be seen and you should be acknowledged also. And Nachiket, you're doing a great job in terms of possibly spearheading the UK trip. Kindly make it as memorable as what we are doing it for the Parliament. And I encourage here people who are wanting to be part of it to actually come forward. It will be a very small delegation, but it is going to be extremely effective in terms of the content analysis. Quite likely, we may, other than the House of Commons, also get an invite coming in from the Indian High Commission. So that's what I had to say right now. Unless she comes, we can't foreclose. So I hope she comes early and we can do the honors.
So if there is any other thought, okay, feel free to.
Last but not the least, I think a huge round of applause to the students and to the people who have worked, Archana, Manoj, and the other students. They are actually the lifeline of what is INBA, and I'm very fortunate that, why I'm young is because I'm always amongst youngsters. Manoj, what is the situation, please? Okay. I hope it's not the 2 minutes noodle.
Ram, why don't you talk about the book that you've talked, maybe while we wait.
Suman, I would request you, please. Yeah, no, please. अच्छा नहीं लगता, आप बोलो. Anyhow, talking about the book, for long everybody is discussing about, how to make India an arbitration hub. So we thought we had a brainstorming session inside INBA. We said, why don't actually we devise this in such a way that we have a complete paradigm shift in terms of calling all the functionaries on this. So it could be students, it could be universities, it could be people who are actually practicing. For example, Zahra, I got to know her. She's from the International Court of Justice. And I found her article to be quite phenomenal. She was so forthcoming in sharing with us interesting statistics world over. Ajay Thomas, for instance. So one call to Ajay and he was here. So possibly I had that unique thing along with my colleagues to reach out to people. Main thing was it brought us to a kind of a situation where we could tabulate the questions, leading questions, and got a, hello, welcome Mrs. Meenakshi Lekhi. Ma'am, you came at the right time. I was actually, pitching in for you.
Thank you so much. Thank you.
I hope the parliament session went on well. Ma'am, I hope the parliament session went on well and we are getting bills passed.
Yes, aren't you seeing much more silence than before?
We prepared a few bills for you.
No,
We'll come up tomorrow.
We'll be happy to take over any bill, any suggestion, and any improvement. I should have been here not to speak, but to hear all of you. Happy to see all my friends and happy to feel more normal. And as a lawyer, obviously, one is more normal and up high wherever we wish to be. And all the constraints we feel otherwise as a politician don't exist for lawyers. And unrestrained completely.
Ma'am, today's topic, just to fill you in.
You're on track.
Just to fill you in, we started last time in February 11th on how to make India an arbitration hub. Yeah. So you're going to be part of this August audience today who is actually formally going to release a book which we are wanting to present to the government and to the related agencies on how to make India an arbitration hub. today in the second series, we decided to talk about cyber and especially legislation. Are we ready? So the think tank sitting here, and I must compliment each one of them for their brilliant ideas that they have brought forward, and including specialists and others. So it's a great mix of, consultants, practitioners, general counsels, students, academicians, and thank you for being here, and please now address us.
There are gaps so far as I'm concerned. I have been at the receiving end myself in terms of cybersecurity, and I have personally felt that too much of intrusion is happening. But half the cause we can assign to the agencies which are operating out of the country. So they cannot be a direct control over those agencies because technically they are operating here, but they are not really bound by our system and laws. That's one part of the story. The second part of the story is, in this connected world, how should the cyber regime operate? And how should nationally and internationally laws should operate? Russia and China, for example, have not assigned themselves to certain changes which have happened at global level. But India obviously cannot, because we are a democracy and a very vibrant democracy where all kinds of interest groups operate, and we need to strike a balance. I recently got to know that certain giants in the field of internet and cyberspace are not even paying taxes, for example. And a whole lot of businesses generated in our country. Though I am completely in favor of open markets, free spaces, free markets, but at the same time, if countries which are generating that business, they need to have some sort of benefit out of that. Simple thing, if I give you business, what is my benefit in it? One is that I stay connected is one part of the story, but the second part of the story is you're earning out of my market also. And so far as I am concerned, I would be seeking more from you people, because 3-4 things I wish to share with you. I feel many systems and many kind of intrusions are possible. For example, on something like Twitter, not to boast, but to be very straightforward, because most of you who have known me know me to be a very straightforward kind of a person. So I haven't spent a single rupee to increase my visibility, because I feel if I do that, my message will be reaching the same person over and over again, who probably will be having a lack of handles or a few thousand of handles. So I don't spend money. I'm very clear on that, that your visibility by showing that I have that many lakh, that many thousand, that many million followers does not serve the purpose, because the visibility has to be connected to the real people on whom you are able to create the impression and you are able to communicate. So falsity does not help, because if you go to my handle and you feel impressed, oh, she has so many followers, but in truth my message does not reach so many people, it's a false impact. It's good for my ego, but it's actually not good for my business. So I have been honest in doing that, and I have not spent any money anywhere. The other side of the story is that recently, from March 20th, our government did some internal survey based on the activity profiles of various MPs and other politicians. And it came to track a few people by saying that they, of course, didn't go into the impressions, engagements, that kind of nuanced research, but I'm sure they have done that research, which they have not shown it publicly, but at their level, they have done that research and they have worked at it. Not to again boast, but my engagements have been fairly decent. But post that particular day on which the study was done, all of a sudden followers have disappeared. So somebody who used to get something like 1,100 to 1,200 followers a day has now come down to a few hundred, 100, 200. And on a particular day when I was speaking, I would be speaking in the parliament, that day some tweets will hit the top and suddenly you will have a surge of followers or something like that. In spite of that, that somebody raking up Augusta Westland, only 200 followers added up, which from a political perspective and a logical perspective does not make sense. So somebody is tweaking the Twitter. At which level, I can't say, but somebody definitely is tweaking the Twitter because the impressions, the retweets, the other parameters are constant. Something has happened, and interesting part is that certain ambassadors who I have known personally have engaged on certain political and social work or otherwise in the international political scenario. I am not able to see some of those tweets and some of the other tweets. So there is some kind of blockade happening, some visibility issues, both at the level in which my visibility to others and also what I can see. At both levels, there is some manipulation that has happened. That's one part. Second part is Google. I think you guys will have more knowledge than I will have on that. But at certain times you're able to access, certain other times you're not able to access. There can be time delays and lapses, etc., etc. That's happening. Facebook. Facebook as a policy can actually enhance certain posts and actually deplete certain posts. So what kind of neutral media are we talking about? Is this the same media which we have been dealing with, which received 50 crores recently, has come up and manipulated the system? So these systems, which were earlier free for all and were the new democratic media, is also getting manipulated either by way of money or through power or political interests or whichever format you can look at. And that manipulation, according to me, is dangerous for any democratic. The metadata manipulation, sharing, etc., is another aspect for which I am concerned with. Recently, a member of parliament from TMC faked some pictures and showed it on the net. And it was kind of really crazy because the original definitely got tracked is another part of the story. But what do you do with such people? Then one more thing which I felt was a very dangerous trend, that how this medium can be utilized for misinformation. Misinformation about anyone. Chandan knows Aman very well, and for ages. Anyone present here would know Aman very well. Now somebody is propagating Aman to be a lawyer of landless laborers. How many of you would agree with that kind of, statement? But this, and I'm sorry to have shared something personal, I shouldn't have because he's not here and I'm not sort of speaking for him, but I'm just saying the misinformation campaign for which a medium like this can be used. And interestingly, I used to be pretty high on top in terms of Google searches. One of the highest person who was tracked on the net, etc. In 2012, 13, 14. And all of a sudden, somebody called Meenakshi Dikshit has come on the net. And the best part is how many of you are all very learned people. Of course, little partiality because we are all lawyers and obviously we all stand by each other. But how many of you have heard of somebody like Meenakshi Dikshit? So Meenakshi Dikshit tops before Meenakshi Lekhi. Yeah, that's what I'm saying. So this kind of manipulation is happening in the medium. And if this manipulation is allowed, we are hurting the cause of democracy, we are hurting the cause of merit, and we are hurting the real cause for which humanity should work. That is truthfulness, clarity of thought and purpose, and if we allow any system to be manipulated and maneuvered in this fashion, we are really harming, even at a global political scenario, that simply by misinformation campaigns, you can actually change and tweak with the way people think, make certain people's identity disappear, create some identities which don't really exist, and is pretty harmful for the social setup generally. How do we clean up the system? We've seen corruption, we have laws, we have physical verifications, we've seen what happened in Panama leak cases, WikiLeaks, so on and so forth. So if we add up all this, certain systems in the world obviously are operating which can tweak the system the way they wish to. But any right-thinking person, any right-thinking polity needs to deal with this kind of crookedness. And crookedness, which could be engineered with money, power, position, has to be controlled in some methodology or the other. And I would say I'm not here to make a comment, but I'm here to learn that these are the kinds of problems which we are faced with. What is it that people like you have to offer? How do we correct this system? Theft, identity, multiplicity of identities, stealing data. I'll show you something very funny right now. My iPad has a SIM and it will simply not get connected to it. It has a mobile data card. It is just not getting connected to it for past many days. So if I am not at a Wi-Fi juncture, I cannot get connected. Then even on Wi-Fi, only 2 kinds of Wi-Fis I could get connected to. My home has 5 different sets. Only one particular one, only I can get connected to, or my office one I can get connected to. Rest, every other Wi-Fi I'm blocked from. Then I tried to tweak the system by using the phones as hotspots. I tried to do that. Even there, it will be off and on, that sometimes I succeed and sometimes I fail. If I'm traveling outside the country, then again, suddenly some particular information was shared and all of a sudden my iPad ceased completely. Now, these are serious issues. I mean, I don't carry any national secret on my iPad. That's a separate story. But the fact this can happen to a person is pretty dangerous for the social setup, is very dangerous for even the government setups. That such things are possible. Such things are possible to common people. I mean, I always say, I carry no such thing. I lead a very simple life, straightforward life. There's nothing you can find on me. But the fact you can be kept away from the news, the fact you can be kept away from knowledge, the fact you can be kept away from reading, the fact you can be not made aware of the latest changes which are happening so quickly is dangerous for any social and political setup, and we need to fix the system. On the contrary, sometimes I feel of course, efficiency increases with internet, and all of us have got so hooked onto it that we can't imagine life without it. But I come from a generation which did not have internet, and I come from a generation when we used to type on manual typewriters as well. So sometimes I feel that was a safer mode because less chances of stealing, less chances of hacking, less chances of people spying on you. Whether they discover anything or not is a separate story, but at least you could sleep peacefully. We are living in a very, very dangerous and challenging world, and I really don't know sometimes whether to be connected is a good idea or a bad idea. Because sitting anywhere, your missile systems could be with somebody else. Your entire mass data could be with somebody else who can just, with a single tweak, can really change everything. So I think these are the systems we need to work very closely. and efficiently. And if I can take you back to what the Prime Minister had to say, that India can not only be the hub for arbitration and the legal services, which we are obviously very good with, but we should work on cybersecurity because we are really good with in technology also. We have some of the best brains in the country. How good are we to stay one step ahead of others in cybersecurity network? We can't operate like Russia and China because of our political setup, and we don't intend to mimic those countries, but keeping ourselves as open as we are we working towards higher vulnerability quotient? And if we are, then we need to correct that system as well. Thank you, friends. Thank you very much.
Ma'am, on that front, I just wanted to inform you we would be actually bringing out a book on the proceedings of the conference today, and also making certain recommendations to the government on cybersecurity as well as the amendments that we can be bringing out on cyber law.
Fantastic.
So that would be
I'll be taking up your cause.
Thank you so much.
Ma'am, you raised a question about Prime Minister wanting to make India a great cyber nation. Just one food for thought. And I had shared that Mr. M.K. Narayanan, the former National Security Advisor, said that there is going to be a shortage of 2 million specialist people in the world to tackle. Why don't we take it up and make India that? Why 2 million? Maybe we could give even 20 million people through the Skill India movement.
Absolutely, absolutely. Not to undermine anybody, but I feel the education network systems, the way past decade country has worked is not really up to the mark. So we need to do a lot. People are sitting with degrees but do not have the adequate requisite qualification to run certain offices, and that is why we need to work at that level as well. I was very happy to learn this morning, one news came in where students from Vishwaraya Engineering College in Bangalore are basically making satellites, mini satellites to be launched by ISRO, which I really felt elated. The new GPS system which we will get, Navik, is fantastic. We have some of the best brains, I always believe. I said, be it law or be it the science and technology, with paucity of resources that country has faced over so many years, people have managed not only to survive, but to live up to global expectations, because we basically are a very, very intelligent nation. And the civilizational quotient that we have, the mathematics, the science, Ayurveda, people call it more culturally driven. I look at it from science-driven subject. We have been very scientific people in the world. At the same time, somewhere the breakdown of institutional support over the years has caused a lot of decline. I think we as a country and every aspect of each field, we should all come together to help the cause of the nation building and work on all these aspects.
Please go ahead. Ma'am, we have a formal book launch, and since you are here, we'd like to use this opportunity.
Let's do it.
Yeah, thank you. And may I request a couple of these people to just join us for the book launch. Along with you, ma'am, we have Chandar, we have Sanjay, Mr. Tabrez, Salman, Shantanu, Kapil, Suman, Nachiket, and Kanti. Of course, I have 10 books, but why I have called you is a couple of you were there also with us the last time, and that will be the fitness of things. You like the overall content also? I will read it because
Thank you so much.
Sorry, I didn't. Santi, you have the book? Okay, fair enough. No, please hold it. Sir, please hold it. Maybe we have a round of applause, please? Thank you. Ma'am, we'd like to come and represent to the various ministries concerned. Right from maybe the Prime Minister's office to the Ministry of Law to DIPP, the Ministry of Commerce, Richard institution, and of course the chambers. We will be going to the chambers and many others who would be involved with, arbitration, mediation, alternative form of dispute resolution. Our idea is to focus that there is a huge potential in India, and why are we draining our resources by going outside? Rather, there should be a reverse train coming here to use our resources. I think, ma'am, everybody would like to have a group photograph also. So maybe in case everybody can come in, please. So we'll have a better. अब तो experience हो गया यार पिछली बार. Please come यार, छोटे हो तुम, आगे आयो, फायदा तो. ये भी बात ठीक है. कहीं तो फायदा हो.